custody more than 11 years.
I make pardon to make a mental note. Fresh matter against Kate of Dead foods.
One criminal appeal for
Appeal for bail more than 11 years in custody. Please. Another appeal during trial in bail after for bail.
Pardon to mention, my lord, the applicant is in custody since 10 years.
But I may be part in an interim bail and a criminal appeal on the ground of my sister's wedding, which is fixed to for
Reading.
1st of August and serving a copy. Interim bail. Very good. Instruction down.
Yes.
Your lordships can be rejected. It can be taken up before trying to verify. Subject to management.
Why you are so pessimistic in the morning? You may reach there.
If you like to.
Item 25 man. Adjournment.
Why? Why you want adjournment?
Is to smile ill my lord. With time.
There is an interim order in your favor. And probably that you will not be completely. So once you are enjoying that interim order, so you must come up to argue the matter. You cannot adjourn. Tulsi will not pass any order. This for the matter.
Item 39.
39.
We have received the counter on 15th July. Instruction but not yet in received an instruction. You can have after courts.
You want to file the counter affidavit?
Yes, I am for the.
Or you are for the petition? You have received the counter filed by UP1.
Yes.
What do you want?
Prepare for adjournment.
For what purpose?
For instruction, getting instruction regarding the agenda.
His name?
M. Samudraya.
Give the name. You are appearing on behalf of Mr. Dayanand Lanka.
Yes, ma'am.
You also appearing for Mr. Lanka, Dayanand Lanka, Land Counsel for the petitioner. Submits that they will receive the counter affidavit filed by the opposite party number 1 and intends to obtain instruction regarding filing of the rejoinder affidavit, and matter may be taken up. How much time we want? After 2 weeks, this matter will commence from 4th of August 2025.
I may pardon, Lordship, in this matter, I am appealing for OP2, Lordship, but unfortunately, copy has not been solved, Lordship.
Yeah?
Copy has not been solved. Copy of the petition on office of DSA has not been solved.
Then how did you file the
No,
counter?
I am for OP2, Lordship.
Achha. So Mahapatra and counsel for the opposite party number 2 submits that he has not received the petition. Let a copy of the petition be provided to the land counsel for the opposite party number 2 in the meantime. 4/8/2025.
Great.
Right. My lordship at a glance to the tag S. Miller. Tag S. That one civil uprising filed and the
May
affix code has
the similar issue has been pending
that
before the
order.
larger bench, and my Lord Justice, Honorable Justice S.Mishra also is a party to that.
Then I can't hear it.
Now, your Lordship hearing that matter with sitting with larger bench, Honorable Justice,
Okay.
Chief Justice,
Yes.
and Honorable Justice.
We'll simply attend.
That is regarding a black mark, 9 black mark.
Oh, black mark.
That is. And the Honorable Appellate Court directed to hear these matters along with the larger, which is pending before.
Okay.
In this case also the
Order.
yes, my lord.
It's all right.
It's also flag is
The issue is pending with the larger.
It is brought to the notice of this court that in view of the decision of the order passed by the Honorable Supreme Court in Civil Appeal number 7111 of 2025, the full bench of this court is in session over the matter to decide there is a reference of to decide the reference. And this matter may be adjourned. Because this matter, any date has been fixed in that? The date has been fixed 15 May 2025, but on that day the matter has not been listed. Out of this matter after 4 weeks. Along with Swan's total. WA number my lord. 2491 by 2023. Likhing the agent. Please tell you on the matter for yes.
Item 2.
Lordship. Lordship, this is a matter fixed for today for the instruction of the Landed Deputy Solicitor General. Whether that order at Annex 4 has been challenged before the High Court or not. That is the last order, Lordship.
If my lord permits, my learned senior is appearing, my lord permits. Actually, this order has never been challenged. But I have to submit this because I have to, I have to assist this honorable court. I have to say that this order has never been challenged. Rest my learned senior submits. I am ready to argue or my lord permits, then I can file the counter.
Annex 4 you have not challenged.
No, my lord, it has not been challenged. I have taken principal instruction.
May I claim, my lord, we file a detailed counter. It is required to file a counter. Let's keep it after 2 weeks.
File it before the judge, before Justice Raman. Don't take it back.
That was the last order my learned senior, my learned senior has submitted, and your lordship has been pleased to direct to take instruction to that 22 or 21 order. NSF 4 has never been challenged, my lord.
The next question would be that as we have mentioned that whether any high-level committee has been constituted.
Yes, my lord, that was constituted, and that committee has taken a decision.
Any written instruction? This is the minutes of the high-level committee. Last was the first page. That is the finding. Which one? Page number? Last first one. Last first one. Starts from all applicants. That is the minutes of that time. All the applicants of the contractual nursing staffs who are please read it out. Lordship. All applicants of the contractual nursing staffs who are continuing their services at present in Bhubaneswar may be extended another one-time relaxation
in maximum age limit for either 5 years or actual period of contractual engagement at Ames Provincial, whichever is less in the next direct recruitment public NORCET 2021. The scope of the post of nursing officers of Ames Provincial. The same may be rectified by the institute body of Ames in the next meeting as required under the Ames Act. Next week, this will be a one-time age relaxation as a special dispensation to provide the applicants an opportunity to appear in the next direct recruitment oblique NORCET 2021. The applicants will have no claim to any subsequent benefits on account of or on the grounds of services rendered by them during contractual employment period. The meeting ended with.
What do you say, Learned Counsel, for the petitioner? The high-level committee has already taken a decision. I hope that you are aware about this outcome of the meeting. Please unmute yourself. Please unmute yourself.
Malad.
No, Mr. Panigrahi, you please unmute yourself.
Yes, Lord sir. As regards the high-level committee order is concerned, as regards the high-level committee order is concerned, based on which a speaking order was passed, and that was challenged in the subsequent way. That is what the issue is, that Learned Tribunal has set aside that order as well and remanded back that you reconsider, emphasizing their contribution during the COVID period.
Just a minute. The order, on the basis of the order passed on 19/5/2021, this high-level committee meeting was held on 22nd July 2021. So is it your instruction that whatever has been decision has been taken by the high-level committee was also the subject matter of challenge in another original application?
Yes, Lordship.
So what is that number and what order has been passed?
So that is the order here. It is page number, Lordship.
Subject matter challenge.
Which page?
That is Annexure 10, Lordship. Annexure 10, page 94, starting from page 94.
Please show in that order that this high-level committee meeting aspect has been taken into account by the Learned Tribunal.
Lordship. Just a minute, Lordship.
You mentioned that in the page number 100, running page, the respondent communicated the decision of the high-level qualified counsel. And then what happened?
After considering that order, that
what order was passed particularly by
the operating part of the speaking order which was passed and the based on which we are denied the regular access.
Direction respondent to consider the case strictly as per the earlier order of the tribunal.
Lordship, para 16, the operating part.
Showing this order to us. Who has placed
This order,
Who has placed this order before? You have placed this order.
Yes, sir.
This was subject matter of the challenge, another original application, and a subsequent order has been passed. Are you not aware about it?
There are two matters touched today. There are two matters touched. The second matter, that this is direction for that reason. There are two matters.
This WPC number 9923, we passed the order on 6/5/2025, and that order was In the operative part, we asked Mr. Parity to obtain an instruction whether the order under Annexure 4 has been challenged by the respondents in this court or not. The answer is no.
Yes,
Then
ma'am.
the second one is that whether the high-level committee has been constituted for taking the decision on regularization. You place this order. But it appears that this very order was the subject matter of another original application, and the Lineman Tribunal that was disposed of on 8/9/2023 under Annexure 10. And this very high-level committee meeting thing was taken into account, that is there in page number 100. And ultimately, the Lineman Tribunal has been pleased to hold that you come to paragraph number 15, page number 116.
Lordship. May I read, Lordship?
Yes.
On examination of the facts in its entirety and the order of the rejection dated 27th October 2021 annexed 20 vis-a-vis the observation of this tribunal quoted above, rejecting the grievance of the applicant in one line remark that it is not feasible without ascribing any reasons as to why in support of the said decision. Further, the order does not show that the decision was reached after taking into consideration the facts of the matter its entirety noted above, which is divorce the principle of natural justice and the decisions of the Honorable Apex Court, commanding necessity of passing reasoned order by every authority. It is settled law that the observation made in an order by a competent court of law has to be given effect in a letter and spirit and cannot be permitted to be treated as a proper order. Thereafter, 16, in review of the above, the impugned order dated 27th October 2021 annexed 20 is hereby quashed with the direction that respondents to consider the cases of the applicant strictly as per the earlier order of the tribunal in OA number 570 of 2018, emphasized above, and the issue speaking and reasoned order to be communicated to the applicants within a period of 90 days from the date of receipt of the copy of this order. It is seen that the fact of the case in OA number so and so is same and similar to this case discussed above, such the decision would also apply to the applicants with this. With this observation made above, both the OAs are disposed of, parties to bear their own cost. Lordship. After passing of this order, they have issued
taken on 27/10 to 2021.
No, they have also.
Correct.
So the latest one is this decision.
Yes,
that is 8/9/2023, and there the operative part that 27/10/2021 order has been set aside. Been issued to the respondent to consider the cases of the applicant strictly as per the earlier order of the tribunal, and speaking order has to be passed, and that is to be communicated. So this is in favor of you are a party to that order, that these two petitioners in this writ of petition, they are S. Kirti Kumar and who is the another?
Lordship, we are not party to that. We are relying on the similarly situated petitioner.
Okay, what happened after this order was passed under Annexure 10?
That is the Lordship. This is the order impugned before your Lordship.
Which one?
That is the order after having.
Just a minute. You are not challenging the order which you just now placed is dated 8/2023.
Lordship, no. That is under pending. That order is challenged, which is pending. Lordship, the OA is pending
This order has been
before the
challenged again.
tribunal
This OA number,
by the petitioner.
The second, after second order, my lord,
By those petitioners who are party to that.
Yes, sir.
Second order.
after second order,
This
Kindly
means
see
Annexure
page
10. Annexure 10.
after Annexure 10,
Yeah.
thereafter they already committed before the court that
And
they already committed before the court. They filed the MA, taking the another 45 days.
they means who?
Respondents.
Ah.
They filed the MA, pray for the another 45 days for taking the steps for regularization.
Okay, then what happened?
Thereafter, they have already, when the applicant already applied for RT reply, they have already intimated that under consideration, thereafter under submission.
No, that is in respect of those 7 applicants. It is not in respect of you.
Kindly see 118 page number.
Right.
118.
Yes.
This is the order. Mr. S.Mishra, learned counsel for the respondent, has submitted that the department are in process of complying with the order of this tribunal and taking steps for regularization of the applicants.
That means the applicants who are there in that OA number 536 of 2021.
Himanshu Sharma.
So that is, they are not your case.
No, this is the base case, Miller.
Exactly. But not the case of the
We are asking you a pertinent question. These 2 petitioners who are before us in WPC number 9923 of 2025, they are one is Kirti Kumar, another is Ajay Kumar Tinsinwar. So they were not the petitioners or the applicants in that 2 original applications. We
Yes,
have
Lordship.
together and anonymously heard and disposed of under Annexure 10 or the MA which was filed and the order passed under Annexure 11 series.
Lordship, they are not party to that OA.
So now the question is that if you are not a party and no order has been passed in your favor, what do you want now?
Now, Lordship, that is what the case is. As I was not a party,
Which order? 19 to
Lordship,
25.
just allow me. Lordship, as I was not a party to that order, but that was the order similar to my case. I am also a nursing officer. Similar to this, my OA was filed also in 2018. I was relying on that order that as the similar order passed in their case, my case is same to and similar to their, so same order is to be given to me. So this is the position before the tribunal. And what the tribunal has said, tribunal has acted as an appellate authority against their own order and started analyzing their own order and dismissed my OA. That is the case.
that is
Please,
not the case, my lord.
the judicial principle of doctrine of precedent.
Mr. Panigrahi, come to page 33, para 10. Read.
Madam, I'm obliged.
Para 10, page 33, impugn order.
Yes, Lord.
Read it. Undisputedly,
Para 10. Undisputedly, in compliance of the aforesaid order, respondent reconsidered the grievance of the applicant therein, but the same was rejected by the order dated 27 October 2021. Since the prayer was considered and rejected by the order dated 27th October 2021, the pious observation made in the order dated 19th May 2021 become redundant, and it is of no help to the present applicants. Hence, on this score, also the prayer of the applicants for granting the similar relief become untenable in the eyes of the law. Now let's see para 11. Further, the case of the applicants is that the order rejection dated 27th October 2021 was challenged in OA number so and so and so and so. And this tribunal, after finding that consideration given to that order dated 27th October 2021 being no consideration in the eyes of the law by the common order dated 8 September 2023 quashed, and the said order dated 27th October 2021 remitted back the matter to the respondent for strict compliance of the order dated 19th May 2021 in OA number so and so. Hence, according to the learned counsel for the applicants, in view of the order dated 19th May 2021, the applicants in this way is also entitled, now Lordship emphasizing, to the same relief, but we have come across that in compliance with the common order dated so and so, that in 19th May 2021 in OA number so and so, respondents again reconsidered the same applicant therein, but the same was again rejected, and speaking order dated communicated the letter dated 8th of October 2024. In view of the development that took place, the submission of learned counsel for the applicant for passing similar orders like that of OA number is not acceptable, being untenable in the eyes of law. We do remember a well-known legal maxim, interest republicea ut sit finis litium, which translates that it is in the interest of the public that there should be an end to litigation. Further, it may be recorded that if the appointment is made so in a co-termination basis, dispensing with the engagement upon the end of the designated time period is considered a justified decision, as the very nature of such appointment means
One minute,
the employment.
One minute, Mr. Paniti.
Lordship. Now, Lordship.
1 minute.
Yeah, Lordship.
Just a minute. So, if you come page number 34, which is internal page number 12 of Annexure 1, claiming parity with the applicants of OA number 570 of 2018.
Lordship. Because I am also same cadre, same dates.
Ultimately, that was directed to be reconsidered, and ultimately their case has also been rejected by speaking.
Now, for a moment, allow me. Lordship, allow me. That second rejection against which OA is pending. The speaking order is under challenge.
Against this order dated 8/10/2024.
Lordship.
OA is pending.
So, speaking order OA is pending.
OA is pending.
Now, this OA
that is already challenged before this court. By another.
So then, what is parity? Their right is not concretized. Crystallized.
Now, Lordship, allow me to submit. Once an order is passed by a tribunal becomes functus officio with respect to that order. Then the recourse of the legal remedy is that either that order is to be challenged or is to be complied. Now the question is, that order has never been challenged.
Mr. Counsel, the tribunal just remanded the matter for phrase to consider the case. They have considered and rejected. Now rejection order is under challenge. Now how do you say that you are claiming parity with those persons? Because now ultimately relief is
now there is a difference. Just Lordship, bear with me for a moment. I am saying
we are hearing with questions, but you are
Lordship. Yes, and with all clarity I will answer. First OA and second OA. No, sorry, first order whose direction was issued to consider. They issued a consideration by issuing a speaking order. The speaking order was challenged in the second batch of OA, which was set aside and remanded back for reconsideration. The issue of reconsideration was again challenged which is pending before the court,
Yes.
that is OA. This OA pertaining to the first batch OA. This OA against which was terminated by the dismissed by the tribunal. This is which is impugned before your lordship is pertaining to the first batch OA. Now the question is, if a similarly situated petitioner has been given a direction, positive direction, I am only saying
Direction only for consideration.
correct. I am not saying it is a direction for regularization.
You tell us whether you have a right. You don't have a right. They form a policy. They'll relax you and give you. And repeatedly the tribunal says consider, reconsider and all. And that process is going on. What is parity about it? I don't know.
No, lordship, listen here with me for a moment.
Your parity is only for the consideration.
No, lordship, that is what I am saying. There are two issues here. One, whether my rejection is by a regent speaking order.
Now, show us any order whereby any of your similarly situated person have got the regularization. Show us one order, then we will pass that.
No, lordship. That is what I am now. Now, lordship, I am my learned friend.
What is the parity then? If anybody would have got it from your batch, then we could have considered parity and we have given.
Lordship, that is what I
also consider your case. He also consider.
Lordship,
Right
to be considered only.
Kindly see the second order. That order attended already final. Because court has given the time within 90 days. Thereafter, they have already filed. Court
said what? Court said only considered.
Yes.
And then
they have considered.
They are considered and rejected. That is the subject matter of another original application.
We have also submitted in edited notes several judgments, including the present time.
It's all right. You are claiming parity to somebody else, but no relief has been granted to them. So what is the question of parity?
Why not already regularized his section?
Lordship, I am relying on a judgment of this
Delhi High Court
judgment after rejection of the
all
cat.
these things are policy matters. When advertisement was issued, you knew that it is a temporary post for 11 months. You joined, and thereafter it was extended. When the court said that you please consider sympathetically, they consider it, and they say that some relaxation we will give, and relaxation was given. And few of them cases of few of the similarly situated persons were rejected. Again reconsider. Nobody has got it. You show us one order where anybody has got it.
Lordship, that is what I am saying, Lordship.
Considered the high level committee.
Kindly have this order.
Not that decide according the order. I have already annexed.
That needs to be considered.
Staff not contractual basis. Anybody has been, otherwise there is nothing in this.
They have already, in earlier, out of 30, 20 already observed. We have already
20 might have come under that relaxation category. After relaxation, they might have been considered. On the relaxation, you are not coming under that relaxation.
In earlier, in order of first order.
You show us anybody you see who got after that relaxation high level.
In first order, para number 9. Kindly see.
Don't go to the first order. First order has already superseded by another order. Don't go to the first order.
Kindly just to.
Mr. Mahapatra, from their bench, have you given anybody an appointment?
Out of 30
regular appointment. 1 minute. Any regular appointment have you given?
No, Lord.
Not.
Have you got any documentary proof that anybody similarly situated has been regularized? Same staff. Don't show like this. You have to file an affidavit so that we can ask the instruction.
That I'm trying to say, Your Lordship.
Don't say this. Aims, staff nurse, regularization. If you have got anything, give. Don't show that there, this RMS something has been done. We are putting a pertinent question to you. If any staff nurse from this AMS has been regularized, situated, show us the order.
If Madam may kindly peruse for a moment Annex 6, that also shows that we have never allowed anyone. Because there is a high level commendation after the order of the Honorable Tribunal.
Is it a staff nurse case? Which one?
Yes, ma'am.
Yes, that will be Hari Bajpayee, Institute of Medical Science.
Page 32.
First, the RTA reply.
30 analysis 6 manner.
So this order was pronounced on 29/4/2024.
Thereafter,
What relief was given to them?
But my
from the
learned
upper
senior, Mr.
depart-
Panigrahi is saying,
upgrade.
after that, this high level committee meeting was held and this was the decision.
I'll reconfirm that they offered appointment on the regular basis.
Madam, I kindly permit to file an affidavit so that the things can be clarified on readings.
এইটাকু কতবার কি চ্যালেঞ্জ ইজিনা ইনস্ট্রাকশন দেবে কাউন্টার অ্যাফিডেভিট ফাইল করে দাও
Again, sir. That will clarify the position.
Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. During course of argument, the Lineman counsel for the petitioners over there.
There are two petitions.
Petitioners, ଗୋଟେ ଜଣେ ତ ଅଛି ନମିତା ବାରି
Again, Nomida, again.
ସେକେଣ୍ଡରେ ଜଣେ ଅଛନ୍ତି ଫାଷ୍ଟରେ ଦି
First, Kirti Kumari, next Nomita Bari.
ଆଚ୍ଛା ଅଦର ଫାଷ୍ଟରେ ଦି ଜଣ ଅଛନ୍ତି ପିଟିସନର୍ସ ଲେଖିବେ ଏଇଟା ପିଟିସନର There's the decision of the division bench of the Delhi High Court dated 29/7/2024 in WPC number 17291 of 2022, where a similarly situated person service has been directed to be regularized. The copy of the decision be handed over to the Lineman Counsel for the Union of India, who shall not only obtain instruction as to whether the Delhi High Court order has been judgment and has been challenged before the higher forum, before the Honorable Supreme Court or not, and whether the petitioner is similarly situated like the petitioners of the said case. So the matter will be listed 4 weeks after, and counter affidavit, if any, will be filed in the meantime. No notice be issued to opposite party number 7. The so accepts notice on behalf of all the opposite parties number 1 to 6. Extra copies of the writ petition will be served on the Lineman Counsel for the Union of India.
dismiss कर दीजिए
Yes.
सेक्रेटरी डिस्मिस कर दीजिए आई थिंक ऑलरेडी देख है ना सेक्रेटरी को डिस्मिस कर देना
Sir, this copy is yours.
Page number?
पेज नंबर पर लास्ट ऑर्डर
अच्छा ये फर्दर ताजे लगी जाऊँ जैसे जो सुप्रीम कोर्ट इंस्ट्रक्शन हो फिर काटी जाऊँ other submits that the division bench order was challenged before the Honorable Supreme Court in SLPC number 028323 of 2024, and it has been dismissed. The copy of the dismissal order has also been annexed. The documents filed by the Land Council for the petitions are taken on record. Similarly situated or not instruction again, counter affidavit filed for the matter will be still after 4 weeks.
English man.
All actions.
Item 3.
Section 14.
Item 3, Lord. I pray some more time to explain.
All the matters, today, all the matters are.
No, some of the cases, the interest has come, but some of the.
Just then go one by one.
Madam,
So this was to be obtained from district magistrate and collector on go.
on good, madam.
You want more time?
More time.
We'll take up next week. Look on the Land and Council for the state. 6 adjournment till next week to obtain instruction. Ask for the order dated
8/1/15. Nine should.
So if any of the 14 application has been disposed of in the meantime, out of the list.
Yes.
So give those lists.
I have received 3 instructions.
जोड़ा का dispose of
The pursuant to the order of the Honorable Chief Secretary has communicated to all. Some of the cases where I have on discussion found and defective applications are pending. They are not complying the order.
No.
These are the causing delay.
We are
Unless-
not.
But what I mentioned, unless they will be registered, then the days of 60 will count from that.
No, if you accept it and do not register, then which fault is this?
After registration, the 60 days will count.
Yeah.
So they are not providing certain documents. Surplus are there, some of the cases, in all cases. So that's why in the order sheet is maintained that provide the documents.
In this.
An affidavit.
Right, a case ভিতରୁ ଯେତିକ list ଆଜି ହେଇଛି
ଆଜ୍ଞା।
କୋଉ କେସ୍ ର dispose of ହେଇଗଲାଣି କହିଦିଅ
17,855
just ଗୋଟେ
Item number କହିପାରିବେ?
17,855 ମାନେ item number 9 ଟିକେ 9 ଟା ମାର୍କ order ଟା ଇଏଟା instruction ଟା ଦେন ସେଗୁଡା ତ ଇଏ କରିଦବା ବାକି ଗୁଡା ତ କମନ ହଉଛି ଲେଖନ୍ତୁ।
May I submit one thing?
The Land and Council for the state has produced the written instruction received from Collector Puri, which is dated 19/7/2025, wherein it is stated that the miss case number 115 of 2024 has been disposed of on 25/6/2025.
Order includes. Order is your.
And that order has also been annexed to the instruction, written instruction. This is taken on record. The writ petition is disposed of. Yeah.
How would
I come?
Item 10.
Yeah. Would I dispose of it?
Okay.
Say type of लिखी देगा.
And I'm appearing through this.
ऊपर item 10 लिख के दीजिए.
It also item number
11.
9. Just a minute. 9.
10 लिख दो.
So that 10. No.
How would I?
11 item 17,867 first item.
Let us know.
Both the matters. Pull up. 11.
Good 10 and
11 ର first item ଟା dispose of ହେଇଛି।
ଆଜ୍ଞା।
17,000 ऐसे रिट नंबर लिखा है बुझिल ता देरे 17,000 ए लिखा है एठी लिखा है दिस इज देयर ओनली ए कनेक्शन दिस इज आइटम नंबर 11 है ना लिखा है
first item the disposal.
এটা ডিসক্লোজ
Sub-item 17 and 857 not dispose
না
instruction
না
not this.
ଯୋଉଟା ଡିସ୍ପୋଜ ଅଫ ହେଇଯାଏ କହିଦିଅନ୍ତୁ ଆଉ ଅନ୍ୟ ଗୁଡାକ ଆମେ ଅର୍ଡର ପାସ୍ କରିଦେବୁ
17,859.
ଲେଖାଇ ଦେଖିବ ତ ହଁ ଆଉ କୋଉଟା
859 70,000 sub-item 2.
859 ଦିଅନ୍ତୁ ଅର୍ଡରଟା ଦିଅନ୍ତୁ এটা 11 ଗୋଟେ ସବ୍ ଆଇଟମ WPC ନମ୍ବର ମେନସନ ହେଇଛି ତାପରେ
Other record instruction.
other ଆମେ dispose of କରିଦଉଛୁ with observation that from the date of registration it is to be disposed of within this time stipulated as per the statute.
Will not waste court's time unnecessarily.
One thing
Of the date of registration you say na?
to avoid further delay as a lordship on number. So they have to comply that order.
ସେଇଆ ପରା ଆପଣ ତ registration କରିବେ ଆମେ ଲେଖି ଦଉଛୁ that most of the cases have not been registered on account of the defects which have not been removed. So the moment that will be removed, the case will be registered and then the period will
60 days will recon from that day.
Yes, that's that means otherwise again it creates a problem.
We'll say that.
Problem is 60 days will count from the date
No,
of
my lord, may
registration.
I
60
submit?
days will be recon from the day when the
Yes.
defects are cured and it is
Yes.
numbered.
Fourth week. Last package we are giving the report that they are not.
no, we just passing the order. ସବୁ ବାଗେଇ ଦଉ ଲେଖନ୍ତୁ ଏଇଟା ହଉଛି
ଏସବୁ ଗୁଡା
ଆଉ ଯୋଉ ବାକି ଗୁଡାକ ରହିଲା ତା ଦେହରେ କରିଦେବୁ the learning counsel for the state on instruction submitted that defects have not been removed.
invariably case. Learning counsel for the state submits that invariably the applicants used to file applications with the defects under section 14, section 14 with the defects, is the result of which the registration is getting delayed. That's the reason the disposal of such applications are also getting delayed. The mandate of law under section so requires that application under section 14 of SARFAESI needs to be disposed of within a period of 60 days. For sake of ready reference, the provision is the reproduction. Taking into consideration the requirement of law to be disposed, requirement of law to dispose of the application under section 14 of SARFAESI, and also taking into consideration the difficulty faced at the time of registration of such application, we make it clear that the applicants, those who file the application, shall be given limited time for the purpose of curing the defect. Once the defect is cured, forthwith it should be registered, and the limitation period of 60 days as mandated under law as reproduced above shall be reckoned from the day the registration of application is made. Registration application is done. And on that, in that observation, on the basis of the aforementioned observation, the writ petitions are being disposed of.
ଗୁଡାକ ସବୁ ଗୁଡାକ ଏ ଟାଇପର ଅଛି କହିଦିଅନ୍ତୁ 3 ନମ୍ବର
3 ନମ୍ବର ତ already sold the property
4 ତାପରେ
6 7 8
6
to 11
7 8
11
ର ଯୋଉ ବାକି ଯୋଉଗୁଡାକ ରହିଗଲା
3ଟା ରହିଲା
11 ର 3ଟା ରହିଲା ତାପରେ ସେତିକି ଏଟା ଗୋଟେ କମନ ଅର୍ଡର କରିଦେବେ ହେଲା ପଠେଇଦେବେ ସାର୍ ଆମକୁ ଦେଖୁଛେ. Yes, next.
My lord, I am appearing through BC. My lord, may I submit one thing? They should inform us what are the difficulties there in the letter, Miller, so that we'll cure.
These are all 14 application, and we are passing this common order. That yes, next.
33 also. I think 3 also.
Yes, 3, 4, 6, 7, 8.
4, 6, 7, 8.
That they are submitting the property has been sold.
Property has been sold.
14 is not written.
Only for a petition.
Those things are not the issue before us. The issue before us is 14 applications are removed, it is not decided.
Yeah. Next.
Item 5.
Remember, may I please your lordship, in the last order, you were also directed to apprise the honorable court regarding the present status of the matter pending in front of the apex court, madam. I have.
What happened?
All are the pending, madam. Today is fixed before the honorable apex court. Today is the date, madam. 2017 in the status, it has been mentioned there.
Therefore, the Mr. Maharana, Learned Senior Panel Counsel, appearing for the petitioners, file a compliance affidavit in terms of the order dated 24/6/2025 and submitted that the matter is sub judice before the Honorable Supreme Court in a batch of cases.
Batch of cases, sir.
And
4 HLP, madam.
he has filed the relevant documents to that effect with the compliance affidavit. It is taken on the record. Put of this matter 4 weeks after the pardon. Same order we shall apply this court about the development if any meeting and so on with the DAS 16389.
Interim order to continue.
Interim order dated so and so shall continue till next date. 4 saptah pore. Next.
Item 12.
Yes, Mr. Patro.
Here, the petition is challenging the charge memo, the inquiry report, and the
Your challenge before the London State Central Administrative Tribunal that was dismissed the original application.
yes, madam.
What is the that judgment or order?
Order at 501, page number 501, madam.
We can accept.
Madam, uninsured 8.
You are the postal assistant.
Yes, madam.
Baleswar headquarters.
Yes, madam.
Head office, no?
Madam.
So, a disciplinary proceeding was initiated against you.
Yes, madam.
Then you are served with the charge memo, then you filed the written statement, then inquiry was conducted and ultimately it went against you.
Yes.
What was the new challenge before the appellate authority also?
Madam.
Appellate authority modified it.
Yes.
The order of punishment as imposed by the 2 compulsory retirement from service. What modification was made?
Madam, punishment was for reduction of 5 stages of increment from some amount to 12,810. And the appellate authority.
What were the allegation against you?
Misappropriation of government money.
What was the amount?
10,000. Total amount 12,000 something, madam.
12,000. Any criminal case was instituted?
No, madam.
No. Then why the London Tribunal dismissed your original application? You come to the paragraph number 11.
May I submit my document? prior to submission to that order, my previous order of Learned Tribunal at page number, my lord, 175, para 13, my lord.
175.
Same case, para 13, my lord.
175.
My lord. Running page 175.
175 quote bolun. Yeah.
My lord, para 13.
Yeah.
Married, my lord. On Federal Order 15/7/2014, it appears that disciplinary authority has not considered any of the points raised by the applicant while passing the impugned order of punishment. He only agreed with the findings of the IO in toto and imposed punishment on the applicant. However, the fact remains that documents exhibited during inquiry were all Xerox copies, my lord, and no original document based on which charges were sought to be proved had been produced during the inquiry. Secondly, the applicant has laid emphasis on the acknowledgement certificate by the post office in form ASLASS6. There is no such finding recorded either by the IO or the disciplinary authority that if such a certificate had been issued by the applicant in the capacity of postmaster as a token or receipt of the deposits. The entire findings of the IO as agreed to be by the disciplinary authority are based on the statement made by the applicant during preliminary inquiry. It's important, my lord, preliminary inquiry, wherein he had admitted his lapses for non-crediting the amount on and failed to sign the impress pure desta upon additional. Further, the IO has recorded that since the applicant was working single-handedly on 28/11/2007 and 21/4/2007, he was solely responsible for non-credit of the amount. Although these facts had been brought to the notice of the disciplinary authority by the applicant in his representation, the latter failed to discuss on each and every aspect of the matter by cryptic order manner. He imposed punishment on the applicants. At this juncture, it is to be noted that preliminary inquiry is held in order to arrive at a conclusion as to whether there exists a prima facie case against the delinquent or to proceed further in a departmental proceeding. Therefore, use of such document which did not form part of the relied upon document in departmental inquiry by any stretch of imagination has vitiated the proceedings. Respondents have to produce any document to show that they had issued notice to appear at the preliminary inquiry. On the other hand, the appellate authority, without taking note of the contents of the appeal in a cryptic order, enhanced punishment to that of compulsory retirement from service. This apart, when the applicant has been charged for his lapses for not crediting amount of 10,190 plus 2,400, an impression has been given in the counter as if the applicant had been involved in preparation of fraud to the tune of 2,03,512. On his own volition, he had deposited an amount of 1 lakh. To make good or loss, in view of the matter, we are of the opinion that matter needs to be reconsidered. Accordingly, we passed the impugned order dated 23/2/2015 and remit the matter back to the appellate authority with directions to consider the matter in the light of observations as made above and pass an appropriate order within a period of 60 days from the date of receipt of this order, my lord.
Thereafter, appellate authority passed the order.
My lord.
What is that order? Appellate authority.
My lord, can I have a glance to order? My lord, 178 page.
Next page, 178.
My lord. The running page 180, my lord. 180, the operative portion, last paragraph, my lord. Last paragraph. The appellant has stated that an amount of 1 lakh has been deducted or recovered from which arrear pay is a misleading statement. As the appellant was identified as fraudster in preliminary inquiry. Again, they relied on the preliminary inquiry.
Yes.
The SPS Baleswar Division Baleswar had his letter dated 22/9/2009 to credit sum of rupees 87,830 and use it. My lord, again, they relied on the preliminary statement, and the Learned Tribunal also relied on preliminary statement. My lord, can I have a glance?
No, what was the ultimate order? 181.
Compulsory retirement.
Reduction of 5 stages.
181.
Operative.
My lord, in view of the discussions made above, IC G. Gurunathan, DPS Headquarters, Odisha Circle, Bhubaneswar, hereby order that the punishment of reduction of 5 stages from rupees 14,430 to 12,810 for for a period of 2 years with effect from 1/7/2014 with a further direction that the appellant will not earn increments of pay during the period of such reduction, and reduction will have effect postponing his future increments of pay issued to the appellant by the SPO's Baleshwar Division, Baleshwar, memo number such and such dated 15/7/2014 be modified to that of compulsory retirement with immediate effect. Accordingly, the order dated 11/2/2020 passed by Honorable Kotak Bench, Kotak, where number certain is compliant with.
This you have challenged in the first.
Yes.
That's the order.
Yes.
500.
In this order, there is no such contention that the order of disciplinary authority is shockingly disproportionate or any discussion about the disciplinary authority matter. Nothing has been discussed in this order.
Recent order which you are challenging, that is dated 23/12/2024.
Mine.
That is annexure
9.
14/5/2020.
Annexure 9 would part.
8. Annexure 8.
Annexure 8 and 9.
8.
Okay, annexure 8.
Come to the operating part then.
11.
Mine.
500, 516, 16, 516.
516.
11.
Prior to that,
Into forest.
Prior to that, may I submit para 8 minute?
Right.
Para 8, 512.
Okay.
We find that this tribunal in earlier order dated 11/2/2020 part in OA number 250/2015 after setting aside order of Appellate Authority 23/2015 remitted the matter to Appellate Authority for consideration of the appeal. The Appellate Authority by order dated 14/5/2020 modified the order of punishment imposed by the DA to that of compulsory retirement with immediate effect. As per Rule 29 of CCA Rule 1965, further opportunity available to an employee to refer revision matter if he has any grievance against the order of the Appellate Authority. In the instant case, it is seen that the applicant submitted application dated 3/5/2021, 6/7/2021 not against the order of Appellate Authority modifying the punishment, but requesting release of differential amount of pay from the date when the order of DA was implemented till the date of order of the Appellate Authority modifying the order of punishment by the order dated 14/5/2020. This itself establishes that applicant did not have any grievance with regard to modified punishment of compulsory retirement which he had challenged in this way. On perusal of the record, it is seen that after his suspension, he submitted a representation 25/9/2009 before the authority concerned, stating therein that he was continuing an acute shortage of cash, the loss in remuneration at the fraud case to the tune of 87,830 has been fixed on him, which he is willing to credit, for which he requested release of his arrears salary due to enable him to credit the amount of usual to make good of loss caused to the department. It is also seen that, well, it is important. It is also seen that the applicant admitted in course of inquiry, that is preliminary inquiry, that he has responsible for the short credit of amount of rupees 5,060 and 10,190 on 2 dates, but the said amount he had spent for medical operation for his mother wrongly. He has also on his own volition credited the amount when it was detected under examination. It is also based on preliminary inquiry.
But the Appellate Authority's order is you should have filed a review. You have not filed the review.
My lord,
you adjust that remedy.
There is provision of review, but it's not a statutory right, my lord. Appeal is a statutory right, my lord.
No, that's what the finding is. Against the Appellate Authority's order, there is the CCA rule says that you should have filed a revision.
My lord, actually, appeal is a statutory right, my lord. It is not mandatory, my lord.
What happened then? Paragraph 11, just you place.
My lord. In so far as is rare to quash the order of rejection dated 3/8/2021, direct the respondent to release the differential pay from the date of order of DA till the order of Appellate Authority dated 14/5/2020 is concerned, we find that the DA imposed the order of punishment of reduction for 5 stages of increment from 14,430 to 12,810 in the time scale of payment 5,200 to 20,200 for the period of 2 years with effect from 1/7/2014, with further direction that the applicant will not earn increment of pay during the period of reduction, and that on the expiry of this period, the reduction will not have the effect of postponing the future increments of his pay, and the suspension period treated as non-duty for all purposes. The said order of DA was modified by the appellate to that compulsory retirement with immediate effect by the order dated 23/2/2015. and the applicant was no more in service with effect from 2023 to 2015. This tribunal quashed the order of appellate authority and remitted the matter back to appellate for consideration, and the appellate authority, after giving due consideration, finally upheld the order of compulsory retirement of the applicant by the order dated 14/5/2020. Thereafter, the respondents in a well-reasoned order rejected the prayer of the applicant as to why he is not entitled to differential amount during the interregnum period by the order dated 3/8/2021. Therefore, the stand of the applicant that he is entitled to differential amount from the date of order at DA to that of the order appellate authority 14/20 does not arise. Hence, the prayer of the applicant is also rejected. Well, there are two prayers before learned tribunal. First, the prayer is passing of the proceeding. Second prayer is while the honorable learned tribunal was the order of the appellate authority, the differential pay for that period. There are two prayers. This para 11 is for second prayer.
What about the first one?
First one, man.
First prayer he has dealt it. Because in page number 508, your relief sought for has been noted down.
My lord.
And the first one is to set aside the charge sheet so and so.
My
lord. So obviously those were taken care of by the earlier order. And only that part of the order of the appellate order was modified to an extent. So appellate authority has passed this order. Instead of compulsory retirement, he has just passed this order. That instead of filing any review application, you have filed the original application.
My lord, before learned tribunal, that was second round litigation, my lord. In first round, the learned tribunal please to pass the order, my lord. And prior to that, the suit was noticed.
26 years also, 29 also is a revision.
Yes.
My lord, prior to first compulsory retirement order, there was a show cause notice. But after order of reconsideration, there is no show cause notice. My lord, in the first show cause notice, also there is no reason mentioned, my lord, why the punishment order should be enhanced, my lord. And the second order of the appellate authority is also not speaking in reason order, my lord, because the point raised by the petitioner has not been discussed in that order, my lord.
May I submit my lord?
Main important point, my lord.
May I submit my lord?
This petition has been filed by the petitioner, Sarath Kumar Mahanti, challenging such and such. Good as the title. Period the grounds taken in the writ petition to challenge the order. The land counsel for the petitioner submitted that in view of the grounds taken, the interim order passed by the Lineman Tribunal, as well as the punishment order and the order of the appellate authority are not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to opposite party number 6. So far as opposite party number 1 to 5 are concerned, the Lineman Counsel for the Union of India accepted notice on their behalf. Extra copies of the writ petition we served on the Land Counsel for the Union of India. That will be placed 4 weeks after. Counter affidavit, if any, we file in the meantime.
My lord, I have one request, my lord. May I audible, my lord?
Yes.
My lord, request to my friend, because they served the copy, advance copy, Most of the pages are not there. Page 30, 30, other
Acha,
pages are not there.
Mr. Fari, Learning Counsel for the Union of India submits that most of the pages of the writ petition are missing. The Land
Annexes.
Counsel, annexures of the annexures are missing. Land Counsel for the petitioner submits that he will file the complete set of writ petition copies on the Land Counsel for the Union of India. Yes.
Elementary good studies.
प्रकाश बेहरा, नंद किशोर सेठी, in view of the evidence available on record, we are not in a position to accept that the prosecution has established its case against the appellants beyond all reasonable doubt. The reasoning assigned by the Lineman trial court in convicting the appellants seems to be based on conjecture and suspicion, which has got no place in the matter of legal proof of the guilt of accused persons in a criminal trial. And we are of the view that the impugned verdict is nothing but a sheer moral conviction. Thus, we hold that the prosecution has failed to establish the charges against the appellants beyond all reasonable doubt. We are conscious that grave and heinous crime has been committed, and the culprits, whosoever they may be, have taken away the lives of 3 persons, including a minor boy aged about 7 years, and his parents in an extremely brutal manner. But when there is no satisfactory proof of guilt of the appellants, and that in view of the settled principle of criminal jurisprudence, the court must always remind itself that more serious the offense, the stricter is the degree of proof, and that higher degree of assurance would be necessary to convict an accused. We have no other option but to give the benefit of doubt to the appellants, and we are constrained to do so in this case. In the result, the criminal appeal is allowed. The appellants are acquitted of the charges under section 302, 364, 201/34 of the Indian Penal Code. The appellants who are in jail custody shall be set at liberty forthwith if their detention is not required in any other case. Accordingly, the criminal appeal is allowed. The death sentence reference is answered in negative. Before parting with the case, we'd like to put on record our deep appreciation to Mr. Satyaranjan Mulia, Mr. Ramesh Chandra Maharana, Lineman Counsel for the appellants, to also Mr. Pradeep Kumar Panda, Lineman amicus curiae, for the preparation and presentation of the case and assisting the court in arriving at the decision above mentioned. This court also appreciates the able assistance provided by Mr. Devasis Tripathi, Lineman Additional Government Advocate. The hearing fees is assessed to rupees 10,000 in toto, which shall be paid to the Lineman amicus curiae immediately. The trial court records, along with the copy of the judgment, be sent forthwith to the court concerned, and a copy of the judgment be communicated to the DLSA on board so that victim compensation amount of rupees 30 lakh, which was directed to be paid to the minor daughter of the deceased Biranchi Naik, namely Sayana, shall be paid immediately if not already paid.
I agree.
प्रकाश बेहरा नंद किशोर सेठी आपन को जो ट्रायल कोर्ट 3टी दफारे दंडित करी फांसी आदेश देइथिले सेथुरु आमे आपन को मुक्त कलु आपन मानकर अपील अलाउ हैला तेणु आपन मानकर जदि आउ किछि केस नाही ताले आपन जेल रु संगे संगे मुक्त है all the other matters.
Item 13.
I plead your loss. And that the petitioner seeks a direction to the opposite party bank to allow him 3 months time to pay the entire OTS dues. So the OTS application of the petitioner has been allowed by the bank and he has been directed to pay an amount of rupees 1,60,45,000 within 6 days. Under Annexure 2 on 24/6/2025, it was informed that OTS application has been allowed and he is required to pay the amount within 6 days.
Where is that? Where is that?
That Annexure 2. And
come to the operative part.
My lord, we value you as a customer and without prejudice to the bank side, this settlement is being granted on your assurance and undertaking to comply with the terms below without setting any precedent as an exceptional case, and it is valid and effective only till June 30th, 2025. The settlement amount being offered to you is solely extended on your request and based on the circumstances in your particular case. Your account will be closed only after the realization of the agreed settlement amount within the agreed time.
What happened?
My lord, I have paid 51 lakhs within 6 days. Thereafter, my lord, I have been hospitalized due to my illness. I only pray, I do not dispute the amount, my lord. I only pray some more time to pay the entire due.
But in the meantime, interest might have accrued on the amount.
My lord, it is one
that
time.
Amount was there in considered and
my lord,
June 24 order that was passed. So maybe what is your instruction? You are appealing for.
I am appealing for the opposite party.
So what amount he was supposed to pay and how much amount he has already paid?
Lord, in the meantime, my in 2 loan accounts, in loan loan account, he is supposed.
No, loan account you number type very good. We are concerned with this particular loan account.
8838.
Right, 8838.
8838 is supposed to pay the OTS amount 1,35,45,200.
So he has paid, according to him, 50 lakhs.
50 lakhs.
So,
and by letter dated 9 July 2025, the period has been extended till 22nd. That they are not disclosed.
22nd of this
July.
22nd means tomorrow.
Tomorrow.
You have received that letter.
No,
almost he has got 1 month time.
Just.
Not received that letter.
No, your party must have received. You are getting the time.
In anything you got the 1 month.
Your lordship may say 1 more month I will pay the entire due.
Also them, you cannot say. Your
I'm
party
ready to
must
pay.
have received that letter.
See my predicament. I was hospitalized immediately in Visakhapatnam.
My lord, this account.
Can you show us that letter?
My lord, the new letter I have not got the old.
So, tell us the letter date.
Letter date is 9th July 2025. I can file it before launch.
It was extended to. No, we are writing it. Just file it
till 22nd July.
If he is willing to pay, take it and finish it up. Why are unnecessary?
Well, this is very old.
The problem with you people is those who are willing to pay, you don't want to take. You harass them. And people those who don't want to pay, you can't do anything.
My lord,
he's telling that he will tell the client and we file an affidavit to that effect. We are keeping this matter tomorrow. Can you file an affidavit that by this month end or by August 1st week you will clear the entire amount so that this rest of the amount.
By August 31st, Milord, I will clear, Milord, because
When you are to.
one month, Milord, 21.
No, we do not know what is the amount that might have reflected in that.
This is the NPA account of 2007, Lordship.
Amount reflected is
Seଟା again ଗୋଟେ account ରହିଥିଲା 1 crore 35
ये
lakh.
जो account କଥା କୁହନ୍ତୁ ଆପଣ जो a particular account is the now 8838.
Again, that is 1 crore 35 lakh. 45,200.
ତାଦେହରେ ପୁଣି ମିଶେଇ ଦେଇଥିବେ କଣ 50 ନାଇଁ 50 ହେଲେ ତ ସେମିତି ରହୁଛି 85 ରହୁଛି।
टोटल अमाउंट होची 1 crore 60 करे टॉप अप अकाउंट भी अछि मिलर तो दुईटा मिसिकी होची 1 crore 60 lakh 45,000।
You see in this particular letter which you placed, the amount has been mentioned
in paragraph 2 मिलर,
right? Out of which if you have paid 50 lakhs, then
51 lakhs मिलर,
then it remains 80 odd lakhs remains in. We do not know that what would be their figure in that letter dated 9/7/2022. So if you have
deposit 80 lakhs here, interest
deposit that amount.
You deposit that 80 lakhs here in the court, we'll see what can be done. You willing to pay, deposit here within 15 days. Interest part will speak. You can't have both. You can't have the cake and eat it also. You have to deposit.
But extension of quotation is in one level.
You are getting that money, you take it and you deposit here. Insofar as the interest part is concerned, then we will request.
In the 9th July letter, we have asked them to deposit 85 lakh 45,200, which is minus 50,000 from the earlier.
85 lakh?
85 lakhs 45,200, which is minus 50 lakhs from the earlier.
So they have not.
We have not charged. For the extended period, we have not charged.
For extended period, they have not charged anything.
Like that letter I have not received. If my respected senior can give me a copy and take instruction in the matter.
That copy will be given to by lunch. He is telling that in that.
By filing this petition, you are trying to buy the time. That's it is apparent now.
Lord, only my lord, I respect.
If you are willing, why don't you deposit here?
Lord, 1 month time your lordship may give, I will deposit.
This petition is only to buy time. The deposit, so your bona fide deposit here. We'll ask him to take it and finish it up.
May I have a copy?
With great respect, my lord, I am ready and willing to, my lord.
See, ready.
Wind it up. Oh, masses on.
Judicial process are not to be used for this purpose. These are not adjudication process. We are not here to adjudicate. We are here to adjudicate things. This is not adjudication. Admitted amount, pay and finish it up. Why should you use the writ jurisdiction for that? We will waste time. Deposit the amount.
Earlier, my lord, the possession of the property was taken by virtue of the order of this honorable court. He paid the amount and it restored back. Thereafter, he did not pay anything. And in matter of 2007 NP account, my lord. The intention is not to pay.
Dispose of. Tomorrow you will get that letter from him. And we are keeping it to tomorrow because tomorrow is the last date as per that letter to deposit the amount. While we are keeping it to day after tomorrow then. And
the copy may be short of.
Which copy? Acha, I will go. 11.
Yeah.
This writ petition has been filed by the petitioner so and so with a prayer for a direction to the opposite parties to grant 3 months' time for making full and final settlement of the OTS dues as per Annexure 2. On perusal of Annexure 2, it appears that the bank has considered the case of the petitioner as an exceptional basis and agreed to settle the dues of rupees 1 crore 35 lakhs 45,200. Paragraph 2 see you page number 10. Yes. And directed and asked the petitioner to deposit the same on or before 30th of June 2025. The Land Counsel for the petitioner submitted that after receipt of such letter under Annexure 2, which is dated July 26, 24th June 2025, the petitioner has deposited a sum of rupees 50 lakhs. 51 lakh, which is not disputed by the Land Counsel appearing for the ICICI Bank stock. However, the Land Counsel for the petitioner submits that the petitioner could not deposit the balance amount on account of his illness, and in support of such stand taken in the writ petition, medical document has been filed as Annexure 4. The Land Counsel for the bank submitted that after adjusting the amount paid by the petitioner as per the letter dated 24/6/2025, the bank has already issued another letter dated 9/7/2022, extending the time till 22/7/2022 to deposit 85,45,200 stock. The Land Counsel for the bank files such letter, which is taken on record. I'm lekhi delu, the upon file karo. By lunch you file karo. The launch with the file to recognize. You let the time. 8/9/2022. The Land Counsel for the petitioner submits that he has no instruction as to whether any such letter dated 9/7/2022 issued by the bank has been received by the petitioner or not, and the matter may be taken up day after tomorrow, so that he will take necessary instruction in the matter and file an affidavit as to by what date the petitioner can deposit the balance amount as mentioned in the letter dated 9/7/2022. Put up this matter on 23rd of July 2025. A copy of the so-and-so submit that he has instruction to appear for the opposite parties. Let a copy of the writ petition be served on the Land Counsel for the bank during course of the day.
Here, my lord, the amount after the amount, the loan account number may be mentioned because
account,
two loan accounts is
just a minute. This is with respect to loan account number. Annexure 2 रे सेटा लेखा हिची जार चारिटा शेष अक्षर होची 88338 है ना पूरा नंबर टा लिखि देबे ए बड़ नंबर टा अछि ओके
instead of 22, that is 25.
Which one?
9/7/22 lordship called it. It is 25.
9/7.
No, जो date आपण टाकी ले
9/7/25 रे
25.
25 yes 23/7/25 yes.
Item 14.
Item 14, I have the Innocos prayer, my lord.
Why have you not approached the tribunal? You move application there. You want an early disposal of the OA. Move application there.
Time and again I have appeared there.
Have you ever moved trial?
No, I have not filed any.
Then move there.
The pleadings are complete.
Yes, ma'am.
All right. This petition has been filed by the petitioner Siddharth Mahanti for early disposal of original application number 792 of 2014, which is pending before the Land Debt Recovery Tribunal. Land Counsel submits that even though the pleadings are complete and the original application is pending since 2014, but the Land Tribunal is not taking up the matter for final disposal. And therefore necessary direction be issued to the Land and Debt Recovery Tribunal to dispose of the so-and-so at an early. after hearing the land counsel for the petitioner and the limited nature of grievance of the petitioners in the original application is pending since 2014, and it is stated that the pleadings are complete. If any interim application is made before the Guardian Tribunal for early disposal of the said way, the same shall be considered favorably, and suitable date is fixed for early disposal of the original application. With the aforesaid observation, the petition is disposed of. Yes.
Item 15.
Number 15. After regarding one-time settlement, in fact, parties have agreed for the settlement, but you could kindly see page 53. Page 53, chapter 6.
You are challenging the possession of these.
I'm in fact saying that I'll pay this amount. The bank has communicated us that we will pay 21,07,000.
No, you are directly not challenging because we will say that you go and approach.
Right.
So indirectly you are telling that.
But I am agreeable to pay this amount subject to fixation of applicable instrument by the bank. Lord, my client, I have taken instruction.
We are appearing for the bank.
My lord, I may be pardon to appear through Vishi, my lord. I am appearing. In 2022, my lord, the petitioner had approached this honorable court, my lord. This honorable court directed to pay this OTS amount, failing which bank is free to take action.
If that is the correct statement which is made by you, then whatever you have mentioned in the cost title is not correct, Mr. Law. He stated that he's approached this court since 2022 a number of times.
My associate is there, my lord, with the copy of the order.
Let my friend give us those numbers. In fact, such an instruction is not given to us. If my learned friend is posted with those numbers, they can give me.
Is it your submission that he has earlier approached this court?
Yes, Mr. Parity.
My lord, this is the order, my lord, I forwarded to LRC's. And in any case, my lord, by
just a minute, let us see one. Address petitioner lagan Samanta Mona Lisa Dheer.
No, it is not Samanta Mona Lisa. This is
my wife and husband, my lord. Account number is same.
That is wife. Account number. Oh, their wife, same. With her husband, same account.
Same account.
Maybe forwarder or a guarantor. In fact, I didn't know this. They should have disclosed it in case of wife. But then, in any way, they are agreeing.
But yeah, this can be a ground of dismissal. What is this? Prayer we are sympathetically considering.
But know. In fact, such an instruction was not with me. Lordship knows it. We never liked or even dare to not to say this number.
And this is the order has been passed. If it was passed, a favorable order was passed, and 1 lakh shall be paid by 31st May 2022, and the remaining balance till sworn. So, what further orders you can find in Tribunal when you are challenging?
We can't supersede this order.
13.4 order you are challenging, and this sort of order without directing you to take reports to the DRT. This order has been passed by a division bench. In spite of that, if you do not comply that, then what can be done?
Not,
have you gone through this order?
In fact, first now I'm seeing this. I didn't know
you
this
withdraw
land
it.
was not disclosed.
Withdraw it.
No, I'll withdraw it. Subject to your lordship will kindly consider this.
There is an order in your favor. The same thing.
This has
You didn't comply. You file a fresh petition without disclosing that.
Or either you file, if their time limit has not been filed, an interim application to extend that period. That can be
in that rate petition. You can do that.
Subject to both my lords will kindly consider. Today there is a fresh settlement. Today there is a fresh settlement arrived at the bank.
See,
bank has me to pay 21 lakhs.
These are not the bona fide.
21 lakh 7,000.
No, this is not bona fide petition.
No, I understand this is not bona fide.
It is not. We know that your client has suppressed
Yes.
about this, then it's
We can't encourage this kind of.
cannot encourage.
So in that case, Lakshmi, permit me to withdraw the writ
The-
with a liberty to file a better application that you
Acha.
will take because.
The learned counsel for the ICICI Bank submits that earlier the petitioner,
Petitioner twice.
white petitioner's husband, Shamant Monalisha Dhir, has challenged the issuance of notice under section 13(4) of the Surface Eye Act before this court in WPC number 372 of 2022 against this particular loan account, which is the subject matter of this writ petition. And the said writ petition was disposed of as per the order dated 5/5/2022. He files the copy of the order which is taken on record. He further submits that the petitioner has not disclosed in the post title about earlier approach by her husband before this court. Since a favorable order has already been passed in the earlier writ petition, and the petitioner has not complied the same, and since he is challenging is now aggrieved by the issuance of a phrase position notice dated 9/7/2025 under section 13(4) of the Surface Eye Act, and the alternative remedy lies in view of the decision so and so before the DRT. We are not inclined to entertain this writ petition, which is accordingly dismissed, giving the petitioner liberty to seek for appropriate remedy. Yes.
And I have filed my Vadatanama, may be taken on record.
Acha, wakalatnama deyichanti, tangalna andali. Yes.
Oblige.
Item 16.
So petitioner prays for restoration. The case was listed on 11/12/2023. The date on which case was listed for hearing, the advocate for the petitioner was absent. Because of non-prosecution, it has been dismissed, my lord. The petitioner should have filed this application for restoration in time. As it has not been filed, an application for condonation of a delay has been filed, my lord.
How much delay?
So the learned division bench who passed that order dismissing your case has also taken into account that you filed the writ petition after 20 years of passing of the order of the Learned Administrative Tribunal, State Administrative Tribunal. So you challenge the order passed in 1990 before this court in 2013. So virtually after 20 years, and when the matter was listed, you are not there. And that is order number 6 also. We do not know what previous orders might have been passed in that, but on that day, which is order number 6, you are not there.
My lord, prior to dismissal of this case, this case was also dismissed because of non-prosecution. But
You are not serious. The issue is 20 years back.
My lord, I was
You
not.
filed, got it dismissed, restore, again dismissed.
My lord, I was not.
And when the division bench took out the matter, nobody was there, again dismissed. Are you a serious litigant?
My lord, I was not advocate in the
Maybe
split petition, my lord.
that will not change this.
My
Will
lord,
not interfere.
My lord,
See, the cause of action 20 years back. Tribunal's order 20 years back.
Ultimately,
That's
even
true.
if, ultimately, even if this petition is restored back to the file, the same question, the same problem would arise, that why are you challenging a 1990 order in 2013?
That is reflected, my lord.
No.
That I have already annexed.
Leave it here.
No, leave.
May I pray, my lord? The petitioner was dismissed from his service while he was discharging his duty as a Sipahi in Special Armed Force. But he is now 70 years old. But so far as reinstatement is concerned, it does not arise. But the statutory benefits as due and admissible to him, if
Maybe the
He will
CMAPL
use
number
everything,
so and so, IN number so and so. It's a application filed for condonation of delay. The stamp reporter has shown that there is delay of 174 days in filing the CMAPL. On perusal of the order dated 7/12/2023, we find that nobody appeared for the petitioner when the matter was called on that day. And this court taken into account that the petitioner has challenged in the WPC number 9412 of 2013, the order dated 31/1990 passed by the Odisha Administrative Tribunal, Bhubaneswar, that is after a long lapse of 20 years. And therefore, the writ petition was dismissed. The relevant paragraph is quoted here in below, quote paragraph number 5. After going through the interim application, we don't find any reason either to condone the delay or to entertain this CMAPL for restoration of the writ petition. Accordingly, the CMAPL stands dismissed, so also the IA. Yes, next.
Item 17.
Number 17, by the order dated 15th of January 2025, Lordships were pleased to direct me to serve copies on my friend, and my friend Mr. Party was supposed to.
Any order has been passed in this case? Which date? There is no order. No. I'm talking for the first time.
15/1/2020.
15/1, so Lordships directed me to serve copies on my friend.
But it should have been declared. Kisi order pass hi.
Nothing.
Both were present.
No, it's all right. But why it has not then been reflected?
Maybe Mr. Lordship directed me to serve copies so that my friend can respond. Might not be written, but we both were present.
No, it's all right.
You have supplied the copy.
I've given a copy.
So, what were the you want to restore the writ appeal?
Yes, restoration of the writ appeal.
Writ appeal order. Where is that writ appeal?
Yes, writ appeal number 543 of 2016.
No, where is that order? 29/2022.
That is page 7 of the CMAPL.
What do you say about this delay?
Do you have objection to the delay?
Or you intend
unmute.
You intend to file any objection, or you want the delay to be condoned, whatever it means.
My lord, is a delay of 2 years.
Yes, 700 odd days.
So if you want to file, we can give you time. There is no problem.
Yes, we will file an objection.
All right, left.
Department will take instance.
IA number so and so. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 760 days in filing the CMAPL. A copy of the CMAPL petition, so also the interim application, has already been served on the Land Council for the Union of India, who seeks some time to file objection to the delay condonation application. put up this matter. We are granting you 2 weeks, you file the meantime.
Privilege matter, yes.
Put up this matter in the week commencing from 11th of August 2025. Objection, if any, to the delay condonation application be filed in the meantime. 11/8/2025.
Not given any sufficient cause.
IN number इटा करिए 585 of 2024 order का पास करिए है ना condonation. Yes, next.
I'm sorry, my lord.
Item 18.
May I please your lordship? For the applicant. I am sorry that I have no brief. I could not trace out these after 7 years.
कौन है
I could not trace out the counter of probably not received my bill.
अपन बारे brief नहीं.
File का misplace है, you could found it. I can take the help of you.
No, you take in your pen drive, take the brief.
Yes, sir. The counter copy your buddy.
No, everything will be supplied to you in the pen drive. So
I'll take.
you are for the petitioner.
Will you get for her? हमारी भी कॉपी नहीं. Yes, will you get?
हाँ, you take it. 2007 मसीहार तो अपना नहीं
हाँ,
जानते.
से नहीं किसी.
Legom,
The solution is there. She will give you a
the
pen drive.
Land Council for the petitioners, also the Land Council for the Union of India, submits that the brief is not available with them, and the registry may be asked to supply the copy of the entire brief in their respective pen drives. Let the registry supply the same. Put up this matter after 2 weeks. Yes. आज ही नहीं जाऊँ तो मैटर अच्छी आज ही नहीं जाऊँ.
Your lordship, item 99 for the appellants, the Mohanty is engaged in a different vote. Your lordship, short date may be fixed.
No, you are for the
Appellant.
appellant.
Service.
Not the top, right?
Which for the other side?
No, I'm for the investing respondent.
What order was passed last time? Refused, therefore it is held sufficient, okay? So.
I have appealed for respondent number 3 only.
3. You are making a mention on whose behalf, madam?
On behalf of appellant.
Appellant, your lordship.
Counsel Gautam Charan Raut.
Pradipta Kumar.
Acha. Pradipta Kumar Mohanty.
Yes, sir.
Senior advocate already. So tell us a date, all of you, so that we can fix it out. If you have got some problem. Next week.
Except 25th and 28th.
25th and? No, next week it is 25th of the week, na? So 28th, so let it be on then 1st of August 22. A mention is made on behalf of Land Senior Advocate Mr. Pradeep Kumar Mohanty for an adjournment to next week. Mr. Ashok Mohanty, Land Senior Advocate, appearing for
Respondent 3.
Respondent number 3, and Mr. Mahapatra, Land Council, appearing for the respondent number 5.
C and 4D, substituted legal yes.
So and so have no objection for to the prayer of adjournment on consensus of all the parties. List this matter on 1st August 2025. Yes.
Item 20.
Yes, item 20.
Yes, please.
Mr. Mishra, who is appearing for the other side?
Other side, fine.
All right. What is the writ appeal for?
Writ appeal, my lord, that is the order of
Past
Honorable Single Judge,
Judge
4.
Annexure 4.
Yes, please. Page 19.
The petition has been allowed. Annexure 2 is liable to be quashed to the extent as observed from the opposite party are directed to issue modified order to accordingly. He is further directed to pay differential career salary for the period from so on. And the pay for linesman A accrued to the position. The opposite party are further directed to fix up the actress also in the regular course only in accordance with law. Yes.
The opposite party, lord, the respondent here was working as a lineman B.
for temporary arrangement, by way of temporary arrangements,
Lineman A लिखा है जी first paragraph पे.
Again?
Paragraph
like say lineman A ର କାମଟା କରିବା ପାଇଁ for temporarily he was deputed.
originally appointed as lineman B.
Yes.
But it was selected, लिखा है जी, the petitioner was selected
Subsequently. Your Lordship may, I'll clarify, my Lord.
Yeah.
Your Lordship may kindly see annexure 1, page 16. The short point involved, my Lord, whether conditional engagements without any financial implication having been accepted for a long period after the tenure of the order is over, can it be challenged by way of waiver? Because he has acquiesced to that, he has acted upon that. Page 16, Your Lordship. Sudhakar Das, that is the respondent. Lineman B under Bhadrak North Elected Division is hereby allowed to remain in charge. Of lineman A and placed at Vasdepur section temporarily without any financial implication until further orders. Subject to reversion at any time and when in charge section will return from their post. So this order was accepted.
No, accepted means what? By
He remained in charge. He remained in charge.
Yeah.
And without any financial implication accepted the.
No, remain in charge mean a taper order pass kala mean temporarily.
Again.
Temporarily does not mean that 10 years, 20 years.
No. So that I'm conscious about.
Yeah.
So subsequently, my Lord, under annexure 2.
Yeah.
In 2009.
He was promoted to
lineman A. So this order
from 2009 after the passing of annexure 2, there is no problem. So the question is that from the period 2004 December
4 to 8, he is claiming that since I was discharging duties of.
So how the learned single judge dealt with it?
The Lordship.
Yes, my Lord.
What is the amount by the way?
Financial. I'm not there because there will be a lot of cases.
No, in this case, no.
We will mention that, squeeze it to this.
All right, my Lord, I will.
ସେଠି ଖାଲି ବୁଝି
ନେଇ ଆସିବି
ସେଇଟା ବୁଝି ଦିଅ
You tell me what is the amount?
Yes, my Lord. With due respect, on application of sections rule 74,
amount
only 4 increment. 4 increment thila, my Lord, the amount.
ସେ ଯୋଉ ପିରିୟଡ ଟା amount
ନେଇ ଆସୁଛି ଆପଣ
ସେଇ କଥା ତ ଏତିକି ଦରକାର the learned counsel for the appellants.
Yes, my Lord. ସେଇ increment ଟା ହଉଛି 200 ଟଙ୍କା 4 ବର୍ଷରେ 800
କେତେ ହବ ମୁଁ
କେତେ total amount on this
ଏଇଥିରେ 5200 ରୁ 20200
ହେଲା ମୁଁ ନେଇ ଆସେ
learned counsel for the appellants.
କଣ ଚଲେଇଛି what kind of remark is it?
କଣ କହିଲେ
କଣ ଚଲେଇଛନ୍ତି ଆପଣ?
ଗ୍ରାଚୁଇଟି ହ୍ୟାଣ୍ଡ ଅଫ୍ କଲି ମାଇ ଲର୍ଡ ସିଏ ଏଥିରେ ଏବେ ଲର ଏକ୍ସପର୍ଟ ଜଜମେଣ୍ଟ ବି ହେଇଗଲାଣି
ଆରେ ମୁଁ କଣ ମନା କଲି
discharging higher responsibility
only he says that he will seek instruction what
one should know where to stop. You are interested
asking me
you are interested for to get some amount. We are asking that what would be the actual amount. This much of instruction you will receive and the matter will be listed next week. What is the necessity of passing any comment to him? This the learned counsel appearing for the appellants seek some time till next week to obtain instruction how much amount the petitioner would be entitled to get if the department is required to pay or the petitioners is required to pay the differential amount as per the order of the learned single judge passed on 10/8/2017 in WPC number 1084 of 2011. Stop. Put up this matter on 30th of July 20. Yes.
Item 21.
Your Lordship, I'm appearing on behalf of Mr. Maharana.
Yes.
He is currently engaged in another court, so kindly pass over.
In another court?
Yes, sir.
Why? Some other bench you want?
No. He is currently appearing in front of another bench, so kindly.
He's on his legs in another court.
Acha, that you say, we thought that you want that.
No.
Mr. Roth, what do you say?
My lord, I can't, if we have some, last time Mr. Biswajit Manti was appearing. Maharana. Achha.
He is held up in some other court, he says, that let it be taken up next week, madam?
Yes, sir.
Yes. A mention is made on behalf of Mr. B. Maharana, Land Central Government Counsel for adjournment next week. Mr. Jayan Kumar Rath, Land Senior Advocate, is present for the respondent. List this matter on 30th of July 2025. Is there any problem, Mr. Roth?
My lord, fixing up to
30 तारीख
30th.
से 29 ଆଉ 31 ଦି ଦିନ ସେ ଅଲଗା ବେଞ୍ଚ ରହୁଛି ତ ସେଇଥିପାଇଁ
31 ରେ ରଖିବେ 30th
30th ରେ ରଖୁଛୁ
30th
ହଁ
ଆଜ୍ଞା ସେଟା ଇଣ୍ଟରିମ୍ ଅର୍ଡରଟା କଣ୍ଟିନ୍ୟୁ
କୋଉଥିରେ ସେଥିରେ ସେ ଯୋଉ ତା ପୂର୍ବରେ ଅଛି ଇଣ୍ଟରିମ୍ ଅର୍ଡର ଟୁ କଣ୍ଟିନ୍ୟୁ ଟୁ ୟେସ୍
Item 22.
May I please do not?
Yes, Mr. Mishra.
Except there is a fairly affidavit also. So being the copy to my lord and page. It's that backgrounds of this case is like this, all the process servers of our judicial department has filed this application for declaring them as a status as Group C. Because so far the retirement is concerned, the age is same, that is 60s. So far status is concerned, your lordship may turn to the notification for the recruitment rules. Annexure 10 at page 56 mil. Odisha district and subordinate courts, non-judicial staff service, methods of recruitment and conditions of service.
प्रोसेस सर्वर को तो काम बर्तन बहुत हल्का ही गला ना
प्रोसेस
आगे जो जाऊ थे वो साइकिल पे लेके नहीं जाए कि सर
एबे गाड़ी
हाँ
एबे मोटरसाइकिल
नहीं मोटरसाइकिल नहीं बर्तन आसीगला आपन करो ये जो ये रे पठे पे ऑनलाइन सर्विस व्हाट्सएप ये से तेणु से गाँ से ये रे बसी कि नहीं मेसेज कर देवे खाली हे गला सर्विस तो कुछ नहीं ग्रीन लाइट टा चली है सुनो yes
so far the law department notification milled under annexure 10 at page 56. The cadre has been defined at page 57.
So let us come to your prayer portion. Let us see what is your prayer.
Fitted as Group C employees and have the order dated 13/3/2000.
Your prayer is that why the process servers will not be treated as Group C employees.
Yes, now it is level 3. Now in the flux of time it is says to level 3.
Level 3. But process servers have been placed in
level 4.
Level 4.
Group D.
So how you substantiate such a claim that by
passage on to page 57
Group D to Group C.
Group C. Salary structure we have not disputed. So for retirement we are also not disputing. We are retired at par with Group C. Page 57.
There is no promotional avenue for them.
Yes, there is an promotional avenue.
Two promotional.
What are the? That is promotional. That is clerical.
Asha. So they can come up to clerical level.
Clerical level.
Asha. Clerical level means that would be level
C.
C.
Level C. Sorry, level
2.
2. So, I am sorry. Level 2. Let's see page 57.
Yes, 57. What is that?
Rules, my lord. That is law department enacted that rules. Odisha district and subordinate courts, non-judicial staff service. Method of recruitment and condition rules 2008.
In that, my lord, the cadre has been defined at page 57. So per group D employees in each district shall constitute an independent cadre consisting of only peer, office peer, sweeper, processor, night watchman, sweeper, Malkhana guard, Malkhana peer, treasury peer, deputy guardian, Jamada, record attendant, and library attendant. So what 5 is concerned, my lord, the post in the cadre shall be grouped as A, B, C, D in accordance with the provisions of the General Administration Department. Resolution number so and so dated 7/6/99 as modified from time to time. Lordship, on to 7/6/1999 cadre rules. That is at page my lord 45, annexure 8.
45.
45. Where the clarification has been made by the GA department. In the government offices into group A, B, C, D. Where your lordship, next page, group C. At page 45.
45
GA department 17655 general.
Okay.
Dated 7/6/1999.
Okay. Please.
Clarification of the post in government offices in group A, group B, group C, and group D. The state government have abolished the erstwhile segmentation of the government employees into gazetted category and non-gazetted category and classified the post in government offices into 4 groups wise group A, group B, group C, group D according to the scale of pay by General Administration Department resolution number so and so. In the meantime, the state government have reviewed the matter, taking into the account various factors, including the fact of the coming into the force of the Odisha revised scale of pay rules 1998. After careful consideration in modification of the resolution number so and so, the state government do hereby decide that the post in government offices shall be deemed to have been classified into the following 4 groups with immediate effect. So per group A, B, and C is concerned, C is for the relation. All the posts in the pay scale, the maximum of which is more than 3,450 and less than 9,000 is a group C. So per group D is concerned, all the posts in the pay scale, the maximum which is 3,450 or less. The administrative department concerned shall according
What is your scale?
My scale at present is 1800, that is GP1. Pay band 1 I am receiving, GP is 1800. Subsequently, this has been amended. That notification has been further amended. And your lordship, that is also I have annexed that document. At page 41.
40.
No.
So then it is very clear that on the basis of the pay scales, the group has been
subsequently
decided. So unless you come to
that scale of pay will not be
3,450, then you cannot enter into group C.
Group C. Subsequently, that has been GA department has been modified.
Where that?
At page 40, my lord, annexure 4.
40. Yeah.
In pursuance to the power conferred under Rule 8 of the Odisha Civil Service Classification Control Appeal Rules 1962. Am I correct?
Yes, sir.
And in supersessions of the GA department notification dated 7 June 1999, except as regard to things done or omitted to be done before such supersessions, the Governor of Odisha hereby directs that all civil posts in the state shall be classified into such categories as mentioned in column number 2.
Come to C and D.
C. 2,800, 2,400, 2,200 and like 1,800, the scale of pay. That is 5,200 to 20,200 in pay band 1. Now our, that is 1,800 and in the pay band 1, that is 5,200 to 20,200. All the process servers of the state as receiving this scale of pay at present. of the pay band that is in 1800. And
D, come to D now. D.
Pardon, yes, D.
1600.
Next page. Group D.
Yeah.
1600, 1500 in the scale of the 4000 to 14,000 somewhat, 4,750 to 14,660 in respectively 1S scale. Explanation for the purpose of this order, pay band in relation to the post means the running pay band specified in column number 5. Of the first schedule to the Odisha's revised scale of pay rules 2008, Department of the Government concerned shall accordingly amend the relevant provisions in the Act statutory rules regulating the recruitment and conditions of service, regulation, code, manual and resolution like this and all other executive instructions which contains any provision contrary to the classification specified.
So this is now in force or any subsequent change?
There is no modification after 2030.
On the basis of this, you are saying that your payment falls in the category of C, so therefore we should be upgraded to C. That's what you're saying.
Now it is level 3. Your Lordship kindly see the Honorable SETI Commission's report, which has been implemented by our state government. That is Annexure 2. The implementation of Honorable Justice SETI Commission's recommendation in respect of non-judicial staffs and subordinate courts of the states, where that is page 36, my lord, serial number 3. Revised to Daftari, Gardener, Jamadar and record keepers.
Revision pay of scale of pay for process server and salaried amine.
Miller. For OSPR rules 1988,
36.
page 36 million.
Is it there?
Okay.
Revision of pay scale of process server and
Miller, salary amine. The existing scale of pay so and so of the process server salary amine under OSPR rules 1998 shall be revised to 2,750 to 4,400. Now, my lord, that has already been enhanced also. That OSPR rules I have annexed before my lord the entire table for since 1974 to 2008. Originally, my lord, they are getting 50 rupees to 70 rupees.
No, that's all right. So, in view of this resolution which was passed in 2008, thereafter they have brought this that you place that 2013 GA department, that July to 2013. There they have stated that this category would fall within group C. So, yes, what do you say, Mr.?
My lord, kindly have the salary structure has changed. Yes. So the salary structure falls under group C. My lord. Now, as of now. So they are saying upgrade us to D to C.
They are not asking any enhancement of salary. They are simply saying that since now because that group is now based on the pay scale.
Yes.
So if their pay scale comes within this Amin's pay scale comes within this particular
pay band
that
falling under C.
So 2,750 to 4,400.
My lord.
Hello. ଆପଣଙ୍କର କହିଲେ ଯେ ସେ 2013 ରେ କହିଲେ ଯେ ଯୋଉମାନେ 1800 ରୁ scale of pay ଥିବ so then so it comes within group C.
My lord, that's true, my lord. Can I have a glance to the counter affidavit filed by the opposite part number 3, my lord. Further affidavit, page 123. In that
paragraph,
my lord, paragraph 3, I am placing. As per rule 3(1)(c) of the Odisha District and Subordinate Group Subordinate Courts, Group D employee method of recruitment and conditions of service rule 2021, a rule made under proviso to Article 309 of the Constitution of India and supersession of all the rules, regulation, instruction, circular, order, except as respect of things done or omitted to be done before such supersession. Process server come under Group D category. My lord, kindly have glanced to the rule, my lord. Dichotomy, because this rule, unless this rule is amended, you say that we can't do it. Yes. Where this rule is creating problem.
My lord, there is no repeal clause there. The earlier rule as on stands. That was the argument, my lord.
They don't have any objection, but for the rule, this existence of this rule, they say that we can't do it.
Yes.
Process
In
server
that
with
respect, I file an affidavit. So far Cuttack is concerned, the London district judge has promoted to go level 3 and treated as them as level 3.
Why this rule is not amended? If there is a dichotomy, you should take steps to amend the rule instead of citing that.
And Honorable Justice
Why don't you
Commission's report, in the Honorable Supreme Court also, you know, also they have annexed that. Honorable Supreme Court has categorically stated that the Commission's report is to be implemented in electronic spirit. That is annexed C by 3.
They say that it can be implemented, but for this existence of this rule, they are facing difficulty.
My lord, rules came into force in the year 2020. There is no repeal clause there. We are governed under 2008 rules.
After this, all this development, you consider after all this development whether you want to amend or that's the only solution.
With that specific instruction, we are keeping this matter. What date of
simply urgent.
Instruction
Let them seek instruction whether they want to amend the rule.
My lord.
The rule that additional further affidavit. Mr. and Counsel for the petitioner has taken us to various documents to suggest that the payment of the process server is falling under the category of Group C. And he has also pointed out to the Shetty Commission report on the basis of which he submits that process servers in view of the changed payment of the process servers, they should be upgraded from Group D to Group C. However, this is whose affidavit? Further affidavit? Further affidavit of the opposite party, that is the further affidavit. Deputy Registrar Naik, however, Mr. Naik pointing out to the counter affidavit, further counter affidavit in para 3, which reads as under. Para 3 submits that in view of the existing rule, it is difficult for the government to consider upgradation of the grade of process server from D to C. Mr. Naik at the same time says that he would seek specific instruction as to whether appropriate steps for the purpose of amendment or repealing of the said rule. What is that rule? Rule 21 is contemplated or not. Odisha district and subordinate courts, Group D employee, method of recruitment and conditions of changing circumstances. In view of the changing circumstances. This is the matter of certain state for the specific instruction. So, you mandate. That's best.
Well, approved for trial by the criminal appeal.
And the petitioner is in jail for more than 10 years. Okay.
Weekly list, item number 1.
May I please, Your Lordship? There are two applicants, both are sentenced for life for the offense under section 302 and 34. That is at page running page 73.
Trial court report, interim applications for consular application. Yeah.
My lord, I have filed a miss case for interim bail because the petition applicant number 1 is suffering from several skin related ailments, my lord.
I iterate instruction लिया अगर bail application दिया है नहीं खाली stay relation of fine और interim bail है interim bail ले instruction no आप हैं
Copy of
copy of yes
Item 2.
admit engage the counsel as per STS next.
Item 3.
My lord, I am appearing for the appellant on behalf of Mr. Manoj Kumar Mahanti, my lord. I remove the defect tomorrow.
Right. CRL of 2006 is pending. What for?
Five C.
Conviction appeal of 2006 is pending without admission.
Some defect is there. Defect
No,
number.
that's all right, but
Admission to choice.
it may be that he might have released from custody and some other report का jail पे ना.
The client is in custody or
Dhenkanal jail.
Huh?
He's in Dhenkanal jail.
Yeah.
You ask the we are keeping this matter. Ask the jail superintendent Dhenkanal to join, and if any such person, namely Sukha alias Sukadev Deuri, is there, ask him to. Yes.
2006 matter.
Send the message immediately.
Wait, we are passing it over.
Item 4.
The convict is a lifer. He was kind enough to grant an interim bail for 3 months. And the convict is in jail custody since 1/5/2009, where he has completed 16 years. Now his parents are completely old and emaciated, and there is nobody to look after them. He's the only sole earning member of his family.
Yes.
Report of the IAC Bhadrapur.
Awesome. Okay. Are the land counsel for the petition land counsel for the state? The land counsel for the state has produced the written instruction dated 27/2025 received from the IAC, Bhadra Federal Police Station. In the effect that the petitioner has not misutilized the liberty and no criminal case has been instituted against the petitioner. The written instruction is taken in report. Considering the submission made by the land counsel for the petitioner that the petitioner has remained in judicial custody in connection with this case for more than 15 years. And the fact that he has not misutilized the liberty granted to him and absence of any chance of early hearing, we are inclined to release the petition on bail alone.
Item 5.
My lord, the offering corporate certificate. Yes. The corporate certificate.
Prisoner's petition at flag E.
The officer corporate certificate for last order.
Mr. Ammopote, आईनजीवी प्रमोद चंद्र शेषपड़ा को नवनियुक्ति କରୁଅଛି ଅଛି वकालत नाम फाइल कर ले
Yes, my lord. Last time
ठीक है peruse the prisoner's petition filed by the appellant wherein prayer has been made to engage Mr. Pramod Chandra Sechpada as his counsel. Mr. Sechpada has filed the Vinama, which is accepted. The names of the other counsel except Mr. Sechpada and his associates shall not be reflected in the cause list henceforth. So there is a stay realization of fine and there is a bail application.
Stay realization and bail.
How many years you are in custody?
Custody, my lord, as for 12 years, but as for custody certificate, 2,990 days.
No, 8 years, 1 month.
8 years, 1 month, 8 years, 1 month, minus the parole days. The parole.
8 years. Total 8 years.
8 years, 9 months, and 60 days.
Your bail application was earlier not rejected by this court?
No, ma'am.
No. 13/7/2015 it was rejected.
13/7/2015. My lord, kindly see PW9, my lord, Dr. Opinion.
आपन गोटे प्रश्न पचराला
My lord.
जे आगुरु आपनकर बेल एप्लिकेशन रिजेक्ट हेची
No, ma'am. रहीची 13/7/2000 आगुरु ओकिलो नथिल सॉरी
नथिले बेली कोन एटा होची आंसर
मैं जानिनी मैम
जातिया को ना मु जानिनी बेली आपनकर नो माने हम भाउची रिजेक्ट हेइनी या भाबियो ना ना
सॉरी
ऑर्डर शीटटा देखलेनी सेट पर थुआ आइची आपनकर ये 13/7/2015 ऑर्डर सुविधा कर ऑर्डर नंबर 3 dated 13/7/2015.
Yes, ma'am. PW9 matter, Dr. Opinion totally says a different matter.
P1 manual is eyewitness.
Eyewitness, but ସେ ଖାଲି କାଠ ଫାଳରେ ମାନେ ମାରିବାର ଦେଖିଛି। Intention of
It's a case based on circumstantial evidence.
Right.
So that body of the deceased, weapon of offense, and motorcycle of the deceased were recovered at the instance of the appellant. And there was some ill feeling also between because of the love affair with one lady. So they were last seen together. That evidence has been adduced by PW1.
He has seen the assault file.
PW1 evidence that is
What do you want to say in PW9?
PW9 doctor opinion kata 20 quintal se mane କାଠ ଫାଳରେ se ମାରିବାକୁ ମାରିନି।
PW1 evidence को ଆସନ୍ତୁ। Paragraph 2 ପଢନ୍ତୁ।
Paragraph 2, the incident took place on 9/2013 evening near Panchayat office and Dolabera. At that time, Dolapada. At that time, I, along with the receipt, were coming at Khajuripada market by a motorcycle. On the way near Panchayat office, Dolapada, we met Dhirendra Pradhan. There was an altercation between Mitujana and Dhirendra over the relationship with one Jasmine Jani. All the accused persons on the Hulla of Dhirendra and Mitu came to the spot and
inquire about the presence of Mitu at the spot.
Of Mitujana at the spot.
The accused
Dhirendra assaulted Mitu on his head by means of a split wood. Immediately, Mitu fell down on the ground, but all other accused persons dealt him a leg blow. Mitu sustained injury at his head. Out of fear, I left the spot.
You come to the PW9, you are pointing out. He has noticed the external injuries.
PW9.
Doctor.
Read it now. Which part you want to show?
Your opinion, my lord. The external injury number 1 and 2 are
anti-mortem in nature.
Anti-mortem in nature. The injury number 1 can be possible by head and burn, trauma, but not sufficient to cause death in ordinary course of nature. Extra injury number 2 is content to ligature mark caused by
what is your submission? कौन आपको submission टा कौन?
से काठ फाळियारे मारची बोली से मरिनी।
काठ फाळियारे injury टा प्रथम injury टा रही छी।
My lord.
ସିଏ ସେତିକି ଦେଖିକିନି ସେ ଲୋକ ଜାଗା ଛାଡି ପଳେଇଲା।
My lord.
ତ ତାପରେ ଏମାନେ ସେଠି ଥିଲେ, ସେ ଯୋଉ ଡିଏ ବାଡେଇଲା ଅର୍ଥାତ୍ ଆପଣଙ୍କ ଆପେଲାଣ୍ଟ ସେ ଜାଗାରେ ଥିଲା।
My lord.
ତେଣୁ ତାପରେ possibility of strangulating the deceased cannot be ruled out. Then how do you say that the doctor's evidence has any advantage to you?
The death is due to experience auspicious arising out of the construction of or compromise compression of the neck by roof and through ligature material.
କଣଟା ମାନେ କଣ? ତଣ୍ଟିକୁ କୌଣସି ଲିଗେଚର ମ୍ୟାଟେରିଆଲ ଦ୍ଵାରା ଚାପି ଦେବା ଦ୍ଵାରା ଶ୍ୱାସରୁଦ୍ଧ ହେଇକିନି ତାର ମୃତ୍ୟୁ ହେଇଛି, ଏଇଟା ହଉଛି ଡାକ୍ତରଙ୍କର ମତ। କିନ୍ତୁ there is an injury over the head। ତ ଯୋଉ ଲୋକଟି PW1 ଦେଖିଲା, ସେ ମୁଣ୍ଡ ମାଡଟା ଦେଖିଲା ପରେ ସେ ପଳେଇଲା ସେ ଜାଗାରୁ। ତାପରେ ଏଇଟା ଲିଗେଚର ମାର୍କ ଦ୍ଵାରା ତାର ତଣ୍ଟି ଚିପାର ପସିବିଲିଟି ରହିଛି। ତେଣୁ how it helps you? Do you mean to say that the doctor's evidence contradicts the version of PW1 in any manner?
What is your case? Is it your case that the cause of death is the reason for the cause of death, that blow or that infliction on the body of the deceased was not seen by any of the witnesses? That's what your case. What do you want to say? ଓଡ଼ିଆରେ କୁହନ୍ତୁ, କିଛି ଅସୁବିଧା
ମାନେ ଜୀବନ ମାରିବାର ଇଣ୍ଟେନସନ ନଥିଲା।
ସ୍ପ୍ଲିଟ୍ ଉଡରେ ଜଣେ ମୁଣ୍ଡକୁ ମାରୁଛି, ସେ ଇଞ୍ଜୁରିଟା ଅଛି ହେଲା। ତାପରେ ସେ PW1 କହୁଛି ଆଉଟ୍ ଅଫ୍ ଫିୟର ଆଇ ଲେଫ୍ଟ ଦି ସ୍ପଟ୍। ତାପରେ ଆଉ ଗୋଟେ ଇଞ୍ଜୁରି ଆସୁଛି ନେକ୍ରେ, ଯୋଉଟା କି ହଉଛି କଜ ଅଫ ଡେଥ୍। ତେଣୁ possibility of
subsequent injury is not seen by anyone. That's what this case.
Yes, Mr. What do you say? He has remained in custody for 8 years.
8 years.
What is your age now?
My lord.
Let's see your age.
You are about 20 years when you filed the appeal.
At the incident, 19 years.
Yeah.
Tribunal decision was
Or the learned counsel for the petitioner, learned counsel for the state. The learned এটা কি আଣିକିନି ଦେଇଛନ୍ତି? ଆପଣ ଦେଲେ ନା ଷ୍ଟେଟ୍ କାଉନସିଲ ଦେଲେ? The learned counsel for the
handwriting decision କଣ ଏଟା? ଏଟା କିଏ କିଛି ଏଟା?
2910
କରିଛନ୍ତି ଆପଣ କରିଛନ୍ତି?
ନା ଷ୍ଟେଟ୍ କାଉନସିଲ।
ହାତରେ କିଏ ଲିଖିଛି?
ହାତରେ ମୁଁ ଲେଖିନି।
Custody certificate issued by the Superintendent Circle Jail Fulbani, which indicates that the petitioner has remained in custody for more than 8 years. The custody certificate is taken on report. Learned counsel submits that earlier bail application of the petitioner was rejected in this case number 360 of 2015. He has order dated 13/7/2015. However, there is no chance of early hearing of the appeal in the near future, and paperwork has not been prepared. He further submits that PW1 is an eyewitness to the occurrence, and he has stated that the appellant petitioner assaulted the deceased Vishwaranjan alias Metu on his head by means of split, whereafter the deceased fell down on the ground and the other accused persons dealt him leg blows and the deceased sustained head injuries. However, the doctor who conducted post-mortem examination, Dr. Lineman PW9, has only noticed one injury over the right parietal region, but the injury which caused the death of the deceased is injury number 2. And the doctor has opined that the injury number 2 is consistent to ligature mark caused by a rough and tough ligature material, and death is due to asphyxia arising out of constriction or compression of the neck by such ligature. He further argued that since there is no material on record that the petitioner is responsible for causing the injury number 2, therefore the bail application may be favorably reconsidered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that apart from the evidence of PW2, there are material on record that the weapon of offense was recovered.
No weapon.
Weapon of offense recovery is the instance. କିଛି ପାଠ ପଢା ପଢୁନାହାନ୍ତି ପଳେଇ ଯାଉଛନ୍ତି ଆସିବ the evidence person. The IO evidence person. IO କେତେ number second?
It will 18 minutes.
Yes, for 3.
So and so he made a statement and gave recovery, so and so, and the split wood which was used as the weapon of offense. Audible, nine. What you just told me.
Why are you making statement without verifying the record? Sorry.
Dead body also recovered. Dead body also recovered.
Dead body, para 3. Para 3 says.
And the dead body was also recovered. Considering the submission made by the land counsel for the respective parties. The nature of evidence available on record and the fact that the bail application of the petitioner was rejected on merit, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and absence of any chance of early hearing, and keeping in view the ratio laid down in the case of Letty versus Ransom, we are inclined to release him on interim bail for a period of 3 months. Stay relation of mine.
3 months. For 3 months, you are granting bail. You prepare properly. After 3 months, you have to argue.
Yeah.
Item 6.
May I please. On this and section 302, 304B for 9080, my lord. Earlier, you also granted him bail for 3 months, my lord. That is dated, my lord, 2/9/2024, my lord.
So what you have done? Have you surrendered? Or?
My lord, surrender certificate is there, my lord.
And you have filed a fresh application.
My lord. After
so have you obtained the conduct? No, my lord. Year number 294 of 2025. There is an application for bail. The counsel for the petition on Mr. Robert submits that after availing the interim bail period as per order dated 2/9/2024, the petitioner has already surrendered before the London trial court and he is now in judicial custody. And he has also filed the surrender certificate.
My lord, in fact, my lord.
He has also filed the surrender certificate. The Land Counsel for the state seeks some time to obtain instruction regarding the conduct of the petitioner while on interim bail.
Flag C, my lord. Custody certificate flag C and a surrender certificate.
No, it is, I'm custody certificate completely conduct put up this matter will be commencing from 4th of August 2025. Yeah.
Item 7.
May I please, Your Lord? My lord, the Finland, my lord, convicted 302/436 along with the other offences for life. He is in custody since 5/1.
Bail application, are you rejecting?
No, no, man. This is the.
So, what is your period of detention?
5/1/2014.
Total कितने वर्ष साल?
14.
तो जाए ना?
11 years.
नहीं से कोरोना पीरियड रे अपन छोड़ा ही
नहीं.
आई कहीं कस्टडी सर्टिफिकेट कहीं
Custody certificate last occasion, though your lordship not mentioned in the order, but directed my lord and friend to take.
Get it. The Land Counsel for the state seeks some time to obtain the custody certificate as well as the instruction related to the criminal antecedent, if any.
One antecedent is there.
And also his conduct inside the jail. The 4th of August 2020.
Item 8.
Item 8 I may be permitted virtually, my lords. My lords, by the last order dated 13/5/2024, Lordship was pleased to grant bail to the appellant for 3 months, my lords, relying on that Letty alias Jaydev Rai and another persisted, my lords. And after that, he has surrendered in time. Surrender certificate is at flag E on your lordship's file, my lords.
Just a minute.
I have filed a fresh bail application, my lords.
Okay. I will obtain that instruction about the conduct and the IN number 3185 of 2024. There is an application for bail. The Land Counsel for the petitioner submits that after availing the interim bail period as per order dated 13/5/2024, the petitioner has surrendered before the Lineman trial court and he is now in jail custody. The copy of the surrender certificate is available on the record. The Land Counsel for the state seeks some time to obtain instruction about the conduct of the petitioner while on interim bail. Put up this matter will be commencing from 4th August 2025.
Item 9.
Agu reject isla ki? Agu reject isla?
2010-2020. 2010-2020.
22/10/2020.
22. I
At
said
that time, it was 6 years longer. It is
Okay, so
16/7, 11 years completed, my lord.
what is the custody certificate? Have you got that?
Final form, I have gone through the NCR.
No, see, final form से जो कोरोना पीरियड रे बहुत लोगों को छोड़ा ही इतला सेउडा को सेंती डेट कैलकुलेशन कल होबनी कारण पे पीरियड गुडा को एक्सक्लूड करियो को जोडा की कस्टडी सर्टिफिकेट आसिले जासी पड़ी.
I have entered appearance.
No, it's all right. Now, look, IN number so on. So this is an application for bail. Land Counsel for the state seeks some time to obtain custody certificate and also information about the criminal antecedent, if any, against the petitioner and his jail conduct put up this matter on 4th August 2025. Yes.
Item 10.
Yes, in this case, there are 4 appellate matters. 3 appeals have been filed before this honorable court. And out of the 3 appeals, the present case is that is
3 appeals, but there are 2 appeals here.
2 appeals. So another is the petitioner, the appellant has been granted bail by this honorable court.
683 of 2017.
What is it?
The other appeal number is criminal appeal number 683 of 2017. That did not
In
come.
that case, the same appellant has been convicted under Section 334 IPC, to arrive for life and fine of rupees 10,000 default 1 year. Then in 307, 5 years, fine of rupees 5,000 in default 6 months, and 341 1 month in civil. In this case, my lord, in the previous appeal, that is 683 2017, this honorable court has granted bail to the appellant minor. This is the order, minor.
How many persons face trial? 4.
4 minor.
So all the 4 have been found guilty.
Guilty minor. Same common judgment.
Under section 302,
Minor.
307, 341 by 34 IPC.
Minor.
And all of them have sentenced to life imprisonment.
Minor.
You say that one of the accused who has been found guilty under section 302, he preferred a separate appeal, that is CRLN number 683 of 2017. And he has been directed to be released on bail.
Well, by this honorable court.
He is
Order, minor.
Just a minute. 683 ta mark kar le, 80 achhi ho gayi. By order dated?
By order dated. Korea 1/2025.
1/1/2025.
IN number 3122 by 2024.
Young counsel, you read that page number 3 padam.
3 minor. Warrant counsel for the petitioner submitted that there are 2 eyewitnesses to the occurrence, that is PW9 and PW10. PW10 has not supported the prosecution case and declared hostile. So far as the PW9 is concerned, he has stated that 4 persons assaulted on the right side of the forehead of the deceased Pitambar Biswar by Lathi, who died at the spot. However, the doctor PW60, who conducted post-mortem examination and proved the post-mortem report in Exhibit 15 that apart from the abrasions on the non-vital part of the body, 1 penetrative stab wound was noticed on the forehead, 1 sharp cutting wound was noticed on the right eyebrow, and 1 stab wound was noticed on the left side of the cheek. It is the further contention of the Lawrence counsel for the petitioner that those injuries which are on the vital part of the body could not have been caused by the lathi, which are stated to have been used by the accused persons. He further stated that there are good chances of success in the appeal and balance of convenience is in favor of the petitioner, and there is no chance of early hearing in the appeal in the near future. The bail application of the petitioner can be favorable.
The assault, according, there are 2 eyewitnesses, one has not supported. The other, PW9 has stated that it was caused by lathi. But on the vital part of the body, there are such type of injuries which could not have been possible by lathi. Because one is stab wound, the other is sharp cutting wound, and penetrative stab wound and sharp cutting.
The opinion of the doctor,
that is the doctor's evidence.
Evidence copy has not been given.
And the injuries which can be caused by lathi, those are on non-vital part of the body. Those are abrasions. So question is that whether this petitioner and the appellant in that CRLN number 683 of 2017, as per the eyewitnesses version, whether they stand on the similar footing or not.
I may be given the copy of the order. I'll examine it.
Just let me. The learned counsel for the petitioner submits that 4 persons face trial in the court of London Session Judge Noapada in ST case number 13 of 2014, and they were convicted under section 302 IPC and other offences and sentenced to life imprisonment. And one of the accused filed preferred separate appeal, that is CRLA number 683 of 2017, and by the order dated 21/2025, he has been directed to be released on bail. He further argues that the petitioner stands in the similar footing like the co-accused who has been granted bail, and he handed over the copy of the bail order to the land counsel for the state. It took some time to verify regarding the claim of Parity. Put up this matter.
Deposition copy may be given.
Deposition copy नहीं जान तो अपन pen drive.
Is there paper book is read?
Paper book भी है. Paper book तो ये नहीं जाऊँ तो ना.
So I may be permitted to take the paper.
The land counsel for the state shall be permitted to take the paper book. Stop. Put up the matter. केबे इतनी तो देखिए नावरा साकिटा देखिए आउ एक के देखिए same footing की नहीं होगा.
Day after tomorrow.
Day after tomorrow.
Pramapecha appears to be same.
Put up the matter on 23rd of July 2025 with CRLA number 43 of 2018. ये order का pass करिए 684 है.
Along 683 আছে 683 2017
683 ତ ଆସୁଛି ତା ଦେହରେ ଖାଲି ଏଇଟା 683 ତ ବେଲ୍ ହେଇଯାଇଛି ଅଲରେଡି ଆଦିର 4 ଜଣଙ୍କୁ ତ ସିଟ୍ ତ ଥିଲା ଜଣେ ଆଉ
ଗୋଟେ 2 ଜଣ ଅଛନ୍ତି ଆଉ ଗୋଟେ ଜଣେ ଅଛି
ଓ 2 ଜଣ ବାଲା କୋଉଟା
ସେ ଯୋଉଟା
694 ରେ 2 ଜଣ ନା 43 ରେ 2 ଜଣ
694 ରେ ଜଣେ
43
ରେ 2 ଜଣ
43 ରେ 2 ଜଣ ଅଛି ଠିକ ଅଛି ନେକ୍ସଟ
Item 11.
See order dated 26.
Usually graduates have more time to conduct and see.
The conduct was there.
They are supposed to get the report.
Custody
the land counsel for the state seeks some more time to produce the custody certificate. Next week, put up this matter in the committee on 28th July 2020. Yes.
Item 12.
In custody since 18/8/2015, the Regularization has submitted the custody certificate. And on 27/11/2024, the Lordship was pleased to grant interim bail for 3 months. He surrendered in time.
Report. Yes, madam.
अपन report तो दी थी ले बोले conduct.
I have submitted the report on 7/7/2020.
Right. So तापर कौन लिखा है जी चौड़टा देखना पड़े पड़ेगा.
Counsel with the state to submit that
Another application filed with which has been numbered as Swanson. Submit that he has not received the copy. Oh, acha.
Twice I have given the copy on 7/7 itself. I have
No. Why you have filed 2 bill applications? One is 192, another is 147. 192 2024 has not been disposed of. So 147 again you have filed. That has been disposed of. This order has been passed. IN number 192, Mr. Nayak.
IN number 192/2024, whereas the Lordship has granted interim bail to him on
Interim bill dispose of
27/11/2019.
कितने से 190?
192/2024.
हाँ 190 dispose of है जी. এটা ভুল লেখা है जी order. Okay ठीक है.
That was disposed on 27/11.
हाँ नहीं ठीक है जी. खाली यही गोटा का सी हो. अपन
192 disposed of on 27/11/24.
IN number 147 टा consider होगी. So କହୁଛନ୍ତି ସେ ରିପୋର୍ଟ କଣ ଆସିଲା କି ମିସୟୁଟିଲାଇଜ କରିଛି କି ନା
No, flag is, the report is
conduct
flag.
is good well manners and so କେତେ ବର୍ଷ ରହିଲାଣି
My lord, he is in custody since 27, sorry, my lord, 18/8/2015. As per the custody certificate which was submitted.
ସେତେବେଳେ ଯୋଉ ଲେଖା
11,
ହେଇଥିଲା
24, that was a 9 year, 2 months, 27 days.
16/11/2024.
That is on record.
ହଁ
That is on
more than
record.
9 years
Right.
ଲେଖା ହେଇଥିଲା
More than 9 years.
ତ ମାନେ 27/11/2024 so
10 years ago.
are the land counsel for the petitioner land counsel for the state এটা লিখিবে IN number 147 of 2025 is an application for bail. Land counsel for the petitioner submits that after availing the interim bail period of 3 months as per the order dated 27/11/2024, the petitioner has surrendered before the Lineman trial court and he is now judicial custody. And since he is in custody for more than 9 years and there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Land counsel for the state has obtained the written instruction from IAC Raurkela police station. Raurkela 9. এটা হচ্ছে কি পুলিশ স্টেশন লবণীপড়া না লবণীপড়া police station Raurkela, that during the period of interim bail the conduct of the petitioner was good and he has complied the condition imposed by the court. Considering the submission made by the land counsel for the respective parties period of detention of the petitioner in judicial custody, fact that the petitioner has not misutilized the liberty while on interim bail and absence of any chance of early hearing. And keeping in view the related case, we are inclined to release the petitioner on bail. Bail allowed.
Item 13.
Let me do. Your bail application was earlier rejected.
My lord, this is for the first time.
So many orders have been passed earlier.
But the co-accused persons has already been granted bail by this court, honorable court.
What is the role attributed to them?
That 376D. Mine is under 376(2)(I). 376D have already been granted bail by this honorable court.
No.
They were supposed to seek instruction. Order number 19. Yes, madam.
Yes, sir.
Order number 19, you are supposed to seek instruction. Land counsel for the state
Yes.
seek some time to obtain instruction regarding the antecedents and all.
And also the custody certificate.
Yes.
Do you have that?
I'll just say.
Are you seeking parity, Mr. Tripathi?
No.
Parity.
Petitioner was just above juvenility. Around 18 years they are claiming, but there is no supporting document. My instruction is not at the time. Custody for more than.
Achi.
Yes, sir. I have this.
Young. Custody certificate, criminal antecedent.
Yes.
Mr. Pradhan को କହିଥିଲୁ ସେ ଢେଙ୍କାନାଳ
Give the order by that time. Let's see. Inusau and others. How many? Inusau and?
Four.
All of them.
Other-
All of them have.
All of them.
Yes.
Custody certificate of Arjun Raza, you know. This is the criminal incident.
It's a minor, gang rape of a minor.
And after that, she committed suicide also.
No?
Immediately thereafter.
Not there. Engagement of the government are in place of so and so. Prisoner's petition has been received for engagement of government advocate in place of Achha. और अगर काउंसिल एटा उन्हें ये करी उसे मना करते हैं देवे नहीं जब से पैनल लिस्ट रे सीरियली करी कि जो जाए चिता पर एंगेज कर दे लेकिन पेरियूज दी latest of the petition of the appellant from jail in which he has requested to engage some other counsel in place of Mr. J. Khan Sama. So and so, से देखी दे उसे लिस्ट सीरियली करी दिया उसे is engaged as this father. Intimate about the engagement of the counsel to the petitioner, but to the appellant. Yes. And matter be placed, say 4 तारीख रे नहीं आसन. So the counsel, अच्छा लिखी दे the newly engaged counsel service supplied with the criminal appeal memo, the judgment copy, the interim application filed for bail. है ना? Yes.
Item 18.
About the newly engaged counsel be reflected.
Newly engaged counsel be reflected in the cause list in place of Julu counsel. Yeah.
If appellant custody more than 7 years, 6 months.
आगु रिजेक्ट कीजिए
माइलर
केबे रिजेक्ट कीजिए
29/4/24
तो कौन हला बताना 376 तो कौन करियो कम 24
6 years.
बस यार रिजेक्ट कीजिए मुझे फ्रेश कंसीडरेशन करियो किसी अच्छी ग्राउंड ना सी सेम ग्राउंड
माइन डाउट
किसी ग्राउंड नहीं तो रखन डाउट अपेयर
माइन
এটা করবেন দুর্গা পূজা করে
Item 19.
Mr. Sahoo.
Appellant is convicted about 9 years in jail by now.
Aguru bail reject कीजिए
Not presently.
बेंच अच्छा 49/22 डिपोजिशन कॉपी अच्छी हाँ कितने वर्ष रहे
9 years, about 9 years.
9 years offense
Offense matter 3762I, purely 2 and 6 Pokso Act.
Pokso Act अच्छी तो अपना नोटिस नहीं होना लेकिन since one of the अच्छा उन Pokso Act रे he has been found guilty. Since one of the offense under which the appellant has been found guilty is under section 6 of the Pokso Act. Let copy of the extra copy of the appeal memo along with the interim judgment and copy of the interim application be served on the land council for this group. Which is meant the same to the IAC of Ambira Kanch police station in the district of Rayala, which will be served on the informant in Ambira Kanch PS case number 614 dated 2/8/2016. The matter will be listed will be commencing from court so and so. The land council for the state shall produce the later showing the service of notice on the informant.
Item 20.
20, Mr. Patnaik.
But I have sent this surrender certificate. Surrender.
You are granted interim bail.
No.
By which order?
Is the order dated 6/3/2025. I number 2281 solely.
Yes, please. Six, 5/25, 6/3/25. That was granted for a period of 3 months. So you have surrendered.
Yes, sir.
So have you obtained the
No.
IN number so and so? This is an application for bail. Land counsel for the petitioner submits that after availing the interim bail period as per order dated 6/3/2025, the petitioner has surrendered right time and he has filed the surrender certificate. Land counsel for the state seeks some time to obtain instruction regarding the conduct of the petitioner while on interim bail. Court of this matter will be commencing from 4th August 2025. Yes.
Item 21.
Study more than 10 years. But okay, what deposition copy?
Deposition copy
No. I'll be.
नहीं जानते था ट्रायल कोर्ट रिकॉर्ड पढ़े आइए तो
Yes.
पढ़े तो सब कॉपी से नहीं जानते the land and counsel for the state submits that he may be permitted to take the deposition copies of the witnesses examined in the trial court from the soft copy of the trial court record. So let the registry supply the same to the land counsel for the state. Court of this matter on 4/8/2025 for consideration of the bail application. Yes.
Item number 3. Your Lordship has directed to remain present the jailer of the Deccan. There on the BC.
अच्छा कितने नंबर देड़ा
Item 3.
काउंसिल अछंदी पर पढ़ेले वही तो
You're there.
नहीं सी तुम कबाट का खाली बताओ
You did see. Call him. Yes. Again. दिखाओ again.
से देखा जाए.
ये अच्छी अनम्यूट करो तुम्हें शुभुनी अच्छी जोरी तुम्हें हाँ ये तुम जो जिला जज ढेंकानाल 20/8/2005 रे तुमको 302 दफारे आजीवन कारादंड देइथिले से अपील गोटे तमे दाखल करथिलो आप 13/2006 आप परठु आउ किछि अपील दाखल करनो ए गोटी अपील
2006 पर अपील करतो
हां
ना कॉर्डिनेट सर
करन किछि तदबीर करनथिलो तम केस रो अपील रो कोन हैला वकील को देइथिलो वकील तो फाइल कर दे चुपचाप बसी गले तापर कोन हैला किछि बुझिनो
ना सर मला
तमे तेबेठु अच्छो जेल रे आ बाहर न भितरु
केते वर्ष हला जेल रे अछो
सर 20 वर्ष होला
20 वर्ष 2006 रु आपण क्रिमिनल अपील जणो फाइल करछन्ती
The poor guy is in the jail for 20 years.
Really unfortunate.
In 2006, a defect was pointed out. You have not cured the defect. We are in 2025. Now you are seeking time for curing the defect.
The defect pointed out by the stamp reporter stands ignored. 5C man key defect or second copy of the petition. Defect ignored. Hard admit. Call for the trial court record. Stop. The appellant was asked to appear through virtual mode from from Dhenkanal jail, from district jail Dhenkanal, and the London Counsel for the state ensured his appearance through virtual mode. We came to know from the along with the jail official, we came to know from the appellant that he is in custody for about 20 years. Stop. The Land Counsel for the state shall produce the custody certificate. Stop. The trial court record would reach to this court during course of this week. And in that connection, email be sent by the registered judicial to the London trial court during course of the day. Put up this matter next week for consideration of the bail application. You have not filed any application for bail. File it.
Immediately file within 2 days.
For considering the interim applications for me. Yeah. Up. Next week, Budhavar, okay. Aji halla 30 तारिख आपणकर केस टाको आज विचार पाई ग्रहण करागला आउ तल कोर्ट रेकर्ड मध्य मगागला तल कोर्ट रेकर्ड यही सप्ताह भितर सेशन जज पठेवा को मध्य निर्देश दिया आसंता सप्ताह रे आपणकर वकील बेल एप्लिकेशन जदि दियंती ताले एटा विचार पाई आसीबो हला हां ठीक बहुत Item 3. This is a criminal appeal of the year 2006 and it has not been placed for admission merely on the ground that there is some minor defect.
Irrespective of defects.
My interlude explanation. The dealing assistant and the section officer shall submit a report as to why the matter was not listed earlier. Stop. The registered judicial shall find out if any of the cases up to 2020 criminal appeal or jail criminal appeal of the year 2020 division bench matters are not placed against conviction with them, are not placed for admission, and if so, the same shall be placed either for orders or for admission by next week. The file be placed before the registered judicial. Yes.
Item 22.
Your Lordship, on behalf of Mr. Panda, I respectfully seek for an adjournment as he is not in. I'm not well.
IA number so this is an application for bail. A mention is made on behalf of Mr. G. Panda for adjournment. It is this matter 4 weeks after.
Much obliged.
Yes, next.
Item 23.
My Lord, that of bail, I number 225/2023. Offense committed under section 302 of IPC. Date of occurrence 15/7/2021.
What time to the taking the custody certificate?
Custody certificate criminal.
The IA number so there is an application for bail and counsel for the state. Seek some time to obtain the custody certificate as well as already order thila.
My Lord, 5/5.
So you want some further time.
Order.
The land counsel for the state seek some further time to produce the custody certificate of the petitioners, also the instruction relating to criminal antecedent put of this matter on 4th of August 2025. Yes.
Item 24.
Has been convicted basing on the last theory, circumstantial evidence leading to discovery and confession of statement.
Yeah, just a minute. You have received the deposition copy.
Deposition copy, yes.
Okay. How many years you are in custody?
I am in custody since 27/6/2019. More than 6 years.
27/3?
27/6/2019.
So you have been found guilty under what offense?
302, 201 and 34.
Okay. Is it a case based on direct evidence or circumstantial?
Circumstantial evidence.
Circumstantial evidence.
So there are two accused. Another accused is a juvenile. He has been custody for 3 years. Thereafter, he has been released.
Let's leave it. So what are the circumstances against you?
Now, there was a feast, village feast. In the feast, the deceased, the co-accused, the accused, and other villagers were attended. after,
No, you come to page number 15. Page number 15, paragraph number 10 of the judgment. There are three circumstances. One is last seen.
Yes,
The other is the leading to discovery of the weapon of offense. And the third is the conduct of the accused. So last seen evidence mean who has stated about it?
and last week, father and mother of the deceased,
That is PW 2 and 5.
2 and 5.
They are the parents of the deceased.
Yes, sir.
What they have stated that
I will permitted to read.
PW 2 version.
I, along with my son,
Just a minute,
PW.
just a minute. PW 2. Yes, read it out.
paragraph 2.
Ah.
The occurrence took place about 3 years back. I, along with my son, had gone to attend a feast where the accused had also come. The accused called my son, the deceased, to go with him to some place. Later, I came to know that he committed the murder of my son. This is the statement of the
What is the motive attributed?
motive is not explained.
Not there.
There is no motive.
No.
So where the dead body was found?
The dead body was found.
ସେଟା ବେକଟାକୁ
At a
କାଟି
different
ଛିଡେଇକିରି
place.
ଝୁଲେଇ ଦେଇଛି।
Hmm?
ବେକଟାକୁ କାଟିକି ଛିଡେଇକିରି ଗୋଟେ ଜାଗାରେ ଝୁଲେଇ ଦେଇଛି।
What is the motive for such a?
No, the called the appellant called the deceased and parents have seen and they went
No, no.
together.
Parents have stated that they have seen, but PW8 contradicted their statement.
No, so far as PW 2 and 5 are concerned,
Yes, sir.
they have stated that they have seen.
Also in the FIR, they have also stated that after taking the bhoji, they return back to their home.
Same witness, para 4, just come. Same witness.
Later during investigation,
Later during the investigation, the
accused was apprehended, and while he was in custody of the police, in my presence, he confessed that he had committed the murder of the deceased and had hidden the weapon. And subsequently he took the police and me to the place where he had hidden the weapon and gave recovery of one
weapon is recovered.
One hammer and another big cat.
So dead body was not recovered at his instance.
No.
Dead body was found at two places.
Two places.
One, that head was there, severed head, and the other is that wrong portion. So after how many days?
After 3 days.
3 days.
3 days.
If he says that he has done, he's confessed, how the dead body was recovered, at whose instance? Police has recovered.
Police has recovered. There is a PW6 may not, I'm not sure exam the PW statement of the
PW6.
3 days after the occurrence, after hearing the news of the death of the deceased, I went to saw the beheaded body of the deceased lying there. The body was lying on the ground and the head was hanging from a tree.
Recovery kaun hala? What is the weapon of offense? Nature of
Katti.
Knife. One small knife, another big knife.
What is the post occurrence conduct?
After the incidents, the petitioners are not there in the village.
Oh, that means absconding.
They are absconding. Because it was occurred after Raja Festival, so there is apprehension that they might be gone to some other places.
What is your explanation in the accused statement? Have you admitted that you have taken the deceased with you? As per the evidence of PW2, the parents stated that you accompanied the deceased, and those questions must have been put nahi hai gaya khali acha.
Question number 3.
Nahi hai gaya mujani nahi mujani. The place from where you were last seen and the place where that dead body was lying, what is the place, distance of the place?
Exact distance is not mentioned, but.
But
yeah,
3
in
days,
another-
3 days after it was
Yes.
found. What is the time when you took the deceased with you? They said that there was a feast going on.
11 PM. রাতে 11
রাতে 11টা বাজে। So is there any statement of the parents that when the son did not return to the house, they went in search of the deceased and wanted to ask you and you were found absent?
No, madam. And the parents have
Just a minute.
apprehension that because of post Raja festival, they might have gone to some other places for observing the Raja festival. That is their apprehension.
Just. हुई और 5 ना? No, there is no such evidence of these two witnesses. बापा माँ दी जन जा कहउचंती जे आसिला से जो फीस्ट रे पुओ हमर डाकी नहीं होला तापरे पुओ ए खाली कहउचंती जे पुओ आमे परे जानलु जे पुओ रो मर्डर हे जाईची आ डेड बॉडी beheaded dead body टा थिला hanging from the head टा थिला हेतु How many years you are in custody?
More than 6 years.
2009?
No, 2019.
19.
2009.
2019.
No, 9.
6.
27/6/2009.
Yes, sir.
19.
No, 19.
19.
19.
No. Stay for some time. We are keeping this matter after from geography. You, in the meantime, you obtained that conduct of the petition of criminal antecedent.
There is no antecedent.
Criminal
Police has also,
instruction.
PW12 has stated that there is no antecedent.
All right. See that. Next.
Item 24.
Mr. Samal and also Kumar Sahoo.
Item 25.
25.
25, my lord. I'm the second item. First item.
Mother, I'm the first item.
What do you want?
I am trying from Adjournment.
Okay. TRL number 221 of 2024.
That's
the Lineman count.
for the antecedent and the
the Lineman Council for the state has produced the written instruction received for the criminal antecedent. I would have gone custody certificate, which are taken on record.
In my
the CRL number 221 there, the Land Council for the appellant, 6 for an adjournment. Which adjournment? What do you want, Mr. Das?
my lord, on 1st May, your lordship has directed me to submit the status of the one antecedent case, that is 506. I have obtained the certified copy.
Second time, Harkar. So
That is criminal appeal 104.
1042 has got one criminal antecedent.
Yes, certified copy. This is, Lord, that has been on production after your lordship's direction on 1/5 May. Last was October.
Just a minute. Wait, 294,506.
Yeah, 294, 506.
How ye custody get there na? Custody.
4
I love that custody certificate.
4 years, 11 months.
corporate secretary to
4
the
days.
Bhagirath Tiwari. That is the CR number 221/24.
No.
No.
Panchanana.
Secondary kontu. First upper adjournment nela.
But my lord, 4 years, 11 months.
Secondary corporate secretary.
ଆପଣ ପାଖରେ ଅଛି କି?
କରିଛି
ନାଇଁ ପରି ହାତରେ କଲା ବସି
ନାଇଁ ପଢାଇ କରିଛି ଯେ
ହିସାବ ଅଲଗା ତାଙ୍କର
ଆଗରୁ ଦେଇଛି ଆଜ୍ଞା ଆପଣ ପାଖରେ ଦେଇଛି ଗୋଟେ କିନ୍ତୁ ଏବେ ଯୋଉ ଟାଇମ ଗ୍ୟାପ ପରେ ଯୋଉଟା ସେଇଠି ଫାଷ୍ଟ ମେ ମାସରେ ଦେଇଛି। ଆଜ୍ଞା
ହଁ 4 years 2 months এটা তা alias function all right
ଆଉ ପରେ modification
हाँ what is the
allegation
25 तारीख 25 4 वर्ष 2 मास 4 वर्ष 25 no weeks to go then we did the other matter 4 वर्ष to
direct evidence है जी
Milord, my humble submission, Milord. Lordship, there is a rival party.
oh এটা injured persons আছে
There are other injured persons. Milord, the only allegation, Milord, the allegation, Milord, the informant, as your Lordship put me question that, the informant, the son, he said that the present appellant has caused that fatal blow as corresponding to PM report. My humble submission, the learned trial court has hold that allegation laid by the PW 12 is not proved. My humble submission, subject to your Lordship's appreciation. That your Lordship paragraph from the judgment I am demonstrating, though only sole witness who has said my attribution so far that fatal assault is concerned.
आसु एका साथ सुनानी हो এটা তো নেটা এটা রকমদু the Lineman counsel for the এটা দেখি
मतलब split up অলগা appellate पे এটা মোটা
Lineman counsel for the appellant এটা হচ্ছে সেকেন্ডারি লেখি CRL নম্বর 200 has produced second apa kali
1042
has obtained the instruction written instruction produce the certified copy of the order sheet to show that regarding the status of the case which was instituted against him in our police station. The certified copy of the order sheet is taken on record. It will record will be. Also put up this matter with CRL number 221 of 2024. Yes. Next. Mr. Bhanjo.
Custody certificate was
Anil, there was an order. Mr. Naik, se jo ame kahithulu jo te custody certificate mein gote
चिट्ठी order भी communicate
ha
ମୁଁ ଏଜି ସାର୍ ମଧ୍ୟ କହୁଛି ତାଙ୍କ ସହିତ ବସିକି ଟିକେ ଡେମନଷ୍ଟ୍ରେଟ୍ କଥାବାର୍ତ୍ତା ନହେଲେ ସେ କଣ କରିଦେବେ ଆମେ କିନ୍ତୁ ଖୋଜିକି ପାଉନଥିବା ଯେମିତି PS କେସ୍ ନମ୍ବର ମାରିଲେ ରେକର୍ଡ ଗୁଡା
କେମିତି ସେଟା ବାହାରିବ ତା ପାଇଁ ଗୋଟେ ୱେବସାଇଟ କ୍ରିଏଟ ହେଇ କେମିତି ଇଜିଲି ବାହାରିଯିବ ମାନେ ମନେ କରନ୍ତୁ ସେଟା ଆଗେ ସିରିୟଲି କରିଦେବେ ଆମର ମନେକର 30ଟା ଜିଲ୍ଲା ଅଛି ମନେକର ଏ ରେ ଆସିବ ଅନୁଗୁଳ ଜିଲ୍ଲା ଅନୁଗୁଳ ଜିଲ୍ଲାର ଟୋଟାଲ ପୋଲିସ ଷ୍ଟେସନ ହଉଛି ଏତିକିଟା ତ ଅନୁଗୁଳ ଜିଲ୍ଲାକୁ ଆପଣ କ୍ଲିକ୍ କଲେ ସେଇ पर्टिकुलर पुलिस स्टेशन को क्लिक कले तापरे ओइटा जे अच्छा जेल को पूरा सेई टाइप जो ये रे आसिले आपण
ऑनलाइन एफआईआर जिम टाइम खोजुचंती
सेई टाइप सेम दिन से आसीबो जे एई माने जेल रे एई ना रे जेतिको थिबे से माने अपलोड कर देबो टाइम टू टाइम ये करी सो दैट वंस यू क्लिक
पीएस केसटा दिता ओरिजिन होता पुलिस स्टेशन केस पीएस केसटा यदि ओरिजिन होता सेही पीएस केस नंबर मार देले केते मुद्दा
पीएस केस का होगी जजमेंट रे पीएस केस होगी ना
हां ना तांगा जो वेबसाइट टा डिजाइन करिवे
हां सेही टाइप
सर्च
दैट वुड बी द वे
पीएस केस इज द बेसिक थिंग
सेटा तो बेस ताकू छाड़ देला अपन पाइबेन कारण तापरे जीआर केस होतिबो कोडी सिटी केस होतिबो तापरे एसटी केस होतिबो यो तो थोड़ा सो बेस टाकू धरले मिल जाओ
तापरे विभिन्न समय विभिन्न कॉन्फ्लिक्ट अलग अलग सब जेल को बोलुचंती
ना सी तार डाटा रही तो सेमन जदी पळेला ସେ ଯଦି ଇଏ କରିବେ ତାହେଲେ ସେଠୁ
ଅଟୋ ଯେମିତି ତାକୁ ନେଇଯାଉଥିବ
ସେଟା କେମିତି ଅଟୋ ନେଇଯିବ ମାନେ ବେଳେ ବେଳେ କନଭିକ୍ସନ ହେଲା ପରେ ସେମାନେ ପ୍ରିଫର କରନ୍ତି ତାଙ୍କ ନିୟରେଷ୍ଟ ଯୋଉ ଘର ଅଛି ସେଇ ପାଖାପାଖି ପୋଲିସ ଷ୍ଟେସନ ଏଇ ଯୋଉ ଜେଲକୁ ଯିବ କାରଣ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ ଆସନ୍ତି ଯଦି ସେମାନେ କୋଉଠି ଦୂରରେ କ୍ରାଇମ ଟା ହେଇଥିବ ତ ତାଙ୍କୁ ରିକ୍ୱେଷ୍ଟ ଆକ୍ସେପ୍ଟ କରାଯାଇ ପଠେଇ ଦିଆଯାଏ ଯଦି କିଛି ସେମିତି ଇଏ ନାହିଁ
very small
ସ୍ମଲ୍ ଥିଙ୍ଗ ଗୁଡା ସେମିତି କିଛି ପ୍ରୋବ୍ଲେମ ନାହିଁ ଜଷ୍ଟ ମନିଟର କରିକିନି ସିଷ୍ଟମ କରିଦେଲେ ପଳେଇ ଆସିବ କିଛି ୟେସ୍ ଏଥିରେ କଣ କୁହନ୍ତୁ
report.
7 years 3 months report dated अच्छा 5 मसीहार माने मे मास आगु रिजेक्ट ही नथला रिजेक्ट कस्टडी सेट एंटीसीडेंट
Antecedent as first page.
फर्स्ट पेज नहीं तो किसी ओके फर्स्ट पेज एक आउकी दीजिए
Debate ଦେଲେ
ନା ଗୋଟେ ପେଜ ଖାଲି
ନାଇଁ ନାଇଁ
এইটার লেখা আছে খালি রেফারেন্স আমি কস্টডি সার্টিফিকেট দেলু বেলি দ্যাট ইজ নথিং
Attended report ନାହିଁ
हाँ नहीं आसुंदु नेक्स्ट वीक London Council for the state submitted the custody certificate which is taken on record. I will submit that a matter may be taken up next week in order to produce the instruction relating to the criminal antecedent, if any, against the appellant. Please this matter next week. Yes.
Item 27.
Yes, Ms. Mahapatro.
Okay.
item number 1 ଟାରେ ସେ ଯୋଉ legal aid ରୁ ଆସିଥିଲା ଚିଠିଟା that he is more than 80 years
I have seen the letter
and in that regard I have filed the
I
application.
have sent the letter for confirmation so I feel जो legal aid
पठेई दीछन्ती
नहीं देई ना 80 वर्ष सदाशिव
just
87 years.
wait. The interim application has been filed by appellant number 1 Sadashiv Majhi.
Again.
Mainly relying on the NALSA sponsor Land Council station, even though he has received the instructions from but that is not in consonance with the order of traffic time. Okay. This is some time to instruct the James Superintendent instructions. Safe time quite report has जी
High Court of
legal services report आसी सदाशिव माझी
86
annexure करतो petition.
no it's there report
is there
86
86 years case 7
4 number
case 7
4 number
age 86 years
4 number
86 years so it is covered by that आप आपनकर माने ये दउछन्ती your authority आप verify कौन करिवे not submitted
ସେମାନେ ବି ଆଜ୍ଞା ଚିଠି ଦେଲେ ବୋଲି ମୁଁ ପାଇଲି ବୋଲି ଏଟା
no
High Court legal service authority
ସେମାନେ ଦେଇଛି।
what
Listen, so and so this is an IA number so and so this is an application for bail of appellant number 1 Sadashiv Majhi. The
31/1/2025 High Court legal service.
The High Court Legal Services Authority provide later dated 31/1/2025 has annexed the format for release of the petitioner on bail on the basis of NALSA special campaign on old prisoners and terminally ill prisoners. On perusal of the said format, it appears that the age of the petitioner is 86 years. Considering the age of the petitioner and in view of the NALSA guideline, we are inclined to release the appellant number 1 on bail. Bail is allowed. And stay election of finals.
My lord, I am appearing in CRLA 516 of 2024 and 259 of
There are other criminal appeals And so far as my lord Omen convicts are concerned, your lordship has already granted them bail. This is a case of 5 murder.
Oh, so you 5 murder.
Again. But they have, my lord, completed more than 10 years.
Again,
My
lord, actually, this is a conflict when the Gochara land was cultivated. And we are also injured in that. Last time we have completed 12 years just this July. And what I say that if we are convicted under 304, then we have almost completed the sentence.
Pasta murder 304.
কিন্তু স্যার এটা একটা spontaneous. তাদের
Spontaneous so you 30.
After পর্যন্ত you puja vacation. Yes, next.
Item 28.
Item 20.
সার্টিফিকেট মগা হয়েছিল অ্যান্টিসিডেন্ট পাইবি মগা হয়েছিল
Please one.
লাস্ট টাইম
IN number 575 of 25. Tari there ही order ta pass करी. That is only the application for release of appellant number 1. है ना? सेटा बेस कोची से जो ये पोजीशन थी लीगल एड और जो सर्टिफिकेट अच्छी सदर फॉर्मेट हाँ
serial number 477.
Yes, next item 28.
The document 498 and 302 IBC, where the appellant was convicted in 3 years for 498 and life imprisonment for life of age of 2 months. And he was in custody since
my lords.
Acha.
He has taken money
All right,
through
all
prisoner
right.
petition or other case. My
Yes,
name may be
sir.
deleted, my lords.
Okay, okay. The prisoner's petition has been received for engagement of Rajya Khan कौन लिखा है जी? तो जफरुल्ला
बोलना जे राजा
कारण
बोलना जे राजा
मुझे नहीं राजा खान so your name is Raja Khan.
Sir, Mona Sakona Raja was wrongly judgment. Let him file a fresh application or otherwise.
but you are otherwise you are इसके Jafrullah is also written.
I file Wakalatana. Yes. My nickname is.
Look, prisoner's petition has been received for engagement of the counsel. Mr. Jafrullah has filed the appearance memo, Wakalatnama, which is accepted. The name of Miss Naidu's land counsel appearing through virtual mode submits that her name may be deleted from the first list. Let the name of Miss Pratyusha Naidu be not reflected in the first list. Yes, Mr. Jafrullah,
I will file of the copy of the deposition.
the land counsel for the appellant seeks some time to solve the deposition copies of the witnesses examined in the trial court on the land counsel for the state foot of this matter, 4th of August 2025. Right? Yes.
Item 31.
Here, my lord, the applicant was convicted for life custody since 13/7/2021. There is no eyewitness to the incident. Only basing on the last seen theory, my lords, and the disclosure statement as per Section 27 of Evidence Act leading to discovery.
Discovery what?
Discovery of the
Ornament of the
victim. He was convicted.
Who identified the ornaments?
My lord,
mother and the
that is
yes,
PW 8, 15
ornament.
and 16.
Deceased had borrowed the ornament from PW 6 and 7.
Okay. This is a lady.
Lady.
Okay.
She, the present appellant, has a relationship with the deceased. On the date of occurrence, the appellant called to the deceased over phone, and this is saying that I am going with the accused to click photo. He borrowed the ornament of PW 6 and 7. Went thereafter, she was for the purpose of clicking photos. She borrowed the ornament. Went with the and she was killed. And she was
thereafter she has not returned. When the dead body was found?
The dead body was detected on 15/3/2021, and she went from the house 8/3/2021.
Achha. And that after the arrest, the ornaments were recovered.
Leading to discovery. And while the accused was in custody, he confessed that he has killed and led the police other witnesses to where he concealed the ornaments that was recovered, and it was identified by the mother of the deceased as well as
So how many witnesses have stated about this last scene?
Last scene, my lord.
PW 13, 14 and 19.
12 and 19. 12, 13, 14 and 19.
13, 14 and 19. Huh?
So what explanation you have given about the last scene?
Last scene, my lord, they are not taking my name.
How?
They are taking the name of the deceased. And after 2 years, they are coming to the court. Yes, we have seen this.
No. Have they not seen in your company?
They say they are saying in that manner that she was in my company, but they do not know me. I am unknown to them. And after 2 years, my lord, can you see?
No, let us come.
Let us see 13. PW 19.
9.
I know the accused.
PW 19.
My lord. I know the accused produced in VC.
PW 19 I know the accused. Produced in VC.
Rishi, on 8/3/2021, while I was sitting in the grocery shop of K. Raja Reddy, I saw the accused and the deceased came to the shop from bicycle, purchased some snacks and water pouch. Thereafter, they went away.
So at different point of time, different witnesses have seen them.
Yes.
So one has seen them in that grocery shop. Similarly, the others have seen.
Yes, my lord. PW
12.
13. Where he has seen.
I know the accused standing in the dock and the deceased Bonita Wood about 2 years back at about 10 to 12 a.m. While I along with Sanatan and Doya to fetch firewood from the Ratnei jungle. While returning, I saw the accused and a girl going in a cycle.
ସେ ଆଉ ଗୋଟେ ଜାଗାରେ ଦେଖି
ଜଙ୍ଗଲ ପାଖରେ
ଜଙ୍ଗଲ ପାଖରେ
where the place of occurrence.
Oh, the dead body was recovered.
Yes,
from
my
there.
And 12 says, my lord, I along with
Similarly, ବିଭିନ୍ନ ଜାଗାରେ ଦେଖିଛନ୍ତି କିଏ ଜଙ୍ଗଲ ପାଖରେ ଦେଖିଛି କିଏ ଦୋକାନ ପାଖରେ ଦେଖିଛି
13 also
Yes.
ତା ପରଠୁ ତାର
Thereafter, my lord, after 10 days or something, the dead body was recovered.
7 days.
7 days after.
In a decomposed state and DNA match with the parents.
How the ornaments which the deceased was wearing came to your knowledge that you buried it in or concealed it in a particular place and gave recovery, because that was identified. If it would not have been identified, matter is different. But what the Learned Counsel for the state submitted, that at your instance such ornaments were recovered and those were identified by the person whom the ornament belonged.
PW8 says, I was sitting in the PS. I did not accompany the SI to the house of the accused. Nothing was recovered in my presence.
What is the ornament code milna?
My lord, PW15. 15, huh? My lord. The accused confessed and led us to the place of concealment in his house at Ambaga village, produced the article hidden under a stone with the help of police and gave discovery of the articles.
What are those articles?
Seizure list, that is in seizure list exhibit P/2.
Those are the ornaments.
Articles कौन से
और ये आयो को जी P/2 रे से ornaments सीच कला. Exhibit P/2. ଲେଖା ହେଇଛି ଗୋଟେ ମାଳ କଣ ଖାସୁ ମାଳ ଗୋଟେ ଲେଖା ହେଇଛି କଳା ସୂତାରେ 10 ଗୋଟି ଜମା ଥାଇ କାନ ଫୁଲ ରୂପାର ସ୍ୱାଂଶ ଚେନ୍ ତାପରେ ଏଟା ଲେଖା ହେଇଛି on production by accused Counsel. Who has identified these ornaments?
Another of the the defense is Radhameshi Sapruta Pai showcase procedural. PW 5.
No TI period has been conducted.
No, TI period not conducted, but it was given to the Jima of the respective PW6.
How you gave it, on what basis? You see, at least in the court, this sort of gold ornament, that is the vital link, na? Kano jadi dead semane identity.
Yes, TI period is.
TI period of the year.
Period in respect of the ornament.
Requisition for TI period, TI period.
देखी दियो पर दिन नबा हला टाइम हेगलानी पर दिन नबा
Your lordship में
এইটু বাকি তবে রকি দেবে হ্যাঁ না ডে আফটার টুমরো
6 7.